Welcome to the 2018 Ohio Center for Law-Related Education's High School Mock Trial State Championship. Good morning, I'm Andy Chow from the Ohio Public Radio and Television State House News Bureau. We're live from the Senate hearing room at the Ohio State House in Columbus. What you will see here today is a polished performance by high school students who will argue a fictional court case live in a real courtroom setting before a panel of judges. What adds to the drama is that all season each team prepares for both sides of the case, and they only found out just last night who will argue for the prosecution and who will argue for the defense. Since last fall, teams of high school students have been preparing and competing against one another, and the top two teams have advanced here today for the championship round. Competing today are teams from Springfield High School and Sylvania Southview High School. The winning team today will represent Ohio in the national competition in Reno, Nevada. This year's case is titled State of Buckeye versus Adam Smith. This case tells the story of a young man convicted in the murder of his ex-girlfriend. Now, 20 years later, Smith has filed a petition for a new trial, alleging ineffective assistance of counsel. Arguing for the prosecution is Team Platinum from Springfield High School in Springfield, Ohio. Their advisor is Scott Hambrick, and the team's legal advisor is Katie Osborne. This is Springfield's first time competing in the finals. For the defense is Team Jasper from Sylvania Southview High School in Sylvania, Ohio. Their advisor is Denny Lyle. Sylvania Southview has been to the mock trial finals 8 times, winning 6 of those times. The mock trial should last about 2 hours before the judges take a break to score the teams. At that time, we'll be back right here with more information about the trial and with interviews with the students. So now, let's go to the main floor of the courtroom.
shall be heard. You may be seated.
Good morning. Before we begin with the trial, I'm going to call on the members of the scoring panel if they would introduce themselves. We'll start from the left side.
Good morning. My name is Caitlin Nassoroff-Johnson. I am the Deputy Director of Outside Counsel in the Office of the Ohio Attorney General Mike DeWine, and I also serve as the District and Regional Coordinator for the Franklin County competitions.
And good morning. My name is Carol Subert Marks. I am a sole practitioner in Lancaster, Ohio. I am also the current year president of the Ohio State Bar Foundation.
Good morning. I'm Justice Mary DeGennaro. I was appointed about a month ago by the governor to serve as the 159th Justice on the Ohio Supreme Court. And this is my first time judging at the state level, and I've been a judge for this very fine program for over 10 years.
Good morning. My name is Randall Comer. I'm an attorney with Martin Brown, Hull & Harper in Springfield, Ohio, and I'm currently the president of the Ohio State Bar Association.
And my name is Jerry McBride, and I'm a judge of the Claremont County Court of Common Pleas. I'm a member of the competition committee, coordinator of the Claremont County District and Regional competitions, and have been involved in mock trials since 1995. This is the case State of Buckeye versus Adam Smith. Are both sides ready to proceed?
Yes, Your Honor.
And this is here on a motion for new trial, obviously. Prosecution's ready to proceed.
Yes, Your Honor.
Defense then may proceed with your introduction of team members and with your opening statement.
Yes, Your Honor. Good morning, Your Honors. My name is Elizabeth Roca, and today I will be providing the opening statement on behalf of the defense, the direct examination of Addison Waranowitz, and the cross-examination of Morgan Reynolds.
Good morning, Your Honors. My name is Lark Yan. Today, I will be conducting the direct examination of Randy Johnson, the cross-examination of Detective Stoneridge, and providing the closing arguments at the end of this hearing. And our witnesses?
Good morning, Your Honors. My name is Kaylin Lee, and I will be portraying the role of Randy Johnson.
Good morning, Your Honors. My name is Shruti Dixit, and I'll be portraying the role of Addison Waranowitz. And here's our bailiff.
Good morning, Your Honors. My name is Felix Griffin, and I will be portraying a timekeeper today.
Thank you. Ms. Roca, that you may proceed then.
Yes, Your Honor. May it please the court. In a criminal prosecution, there can be no stronger defense than presenting an alibi for the time the crime occurred. In fact, it seems inconceivable that a defense attorney would ignore such a basic, fundamental defense. But that's exactly what happened in this case. As the evidence will show, Adam Smith's attorney never investigated his alibi, never called a single alibi witness, and never conducted a cross-examination that would have supported that alibi. In doing so, defense counsel denied Adam Smith his Sixth Amendment right, the right to a fair trial with effective assistance of counsel. Now, in order to succeed on a claim of ineffective assistance of counsel, the Supreme Court established in Strickland v. Washington a two-pronged test the defense must meet. That first, counsel's performance was deficient, and that second, that deficiency prejudiced the defendant. But today, both the prosecution and the defense have stipulated that first prong has already been met. Counsel committed errors that were unprofessional, which leaves this court today with only one question to consider. Was there prejudice? The Supreme Court defined prejudice to mean that the defense must show a reasonable probability that the result of the proceeding would have differed, but for counsel's unprofessional errors. In this particular case, the evidence will show on September 18, 1998, a girl named Haley Lay went missing. Her body was ultimately found buried at Olentangy Park. But building a case upon circumstantial evidence alone, the state claimed Adam killed Haley, buried her body around 5 p.m. that same day. It was a case fraught with errors, but errors counsel never brought to the jury's attention. From her failure to retain experts, to ignoring alibi witnesses, to inadequate cross-examination, the evidence will show defense counsel did little more than just stand by Adam's side during trial. In coming to this conclusion, you'll first hear from Randy Johnson, Adam and Haley's former teacher at Trillium High School. She'll explain that on the day Haley was murdered, Adam was with her, studying for an upcoming test at an after-school homework help session until 5 p.m., the same time the state claimed Haley's body was buried. But her testimony, it's not new. Ms. Johnson will further explain that she reached out to a detective, she reached out to defense counsel, but the evidence will show no one ever called back. No one ever sent Ms. Johnson a letter. No one ever asked her to testify upon the defendant's behalf. But what was even more disturbing was defense counsel's failure to address any testimony that would have supported that opinion. Addison Waranowitz, our second witness, and in fact, the state's witness from the original trial, is an expert on cell phone location technology. She'll explain that at the original trial, defense counsel asked her no more than 5 questions on cross-examination, none of which asked about her opinion, none of which asked if the data she had was consistent with Adam's alibi. But the evidence will show that if she had asked that just one simple question, Ms. Waranowitz would have testified. Adam Smith could have been at Trillium High School and not at Olentangy Park. In the end, defense counsel deprived Adam Smith of one of the most fundamental elements of our justice system, a fair and reliable trial. It's for these reasons, at the end of this hearing, my co-counsel, Lark Yan, will request that the original verdict be vacated and that Adam Smith receive a new trial. Thank you.
Thank you. Ms. Osborne, you may introduce your team members and then make your opening statement.
Good morning, Your Honor. My name is Caroline Osborne, and I, along with my co-counsel, Aman Dhingra,
Good morning, Your Honor.
we represent the state of Buckeye in this matter. We will be calling 2 witnesses. First, Morgan Reynolds.
Good morning, Your Honor.
And second, Detective Billie Stoneridge.
Good morning, Your Honor.
Your Honor, opposing counsel, may it please the court. The jury already heard what they needed to hear. In October of 1999, the defendant was tried for the murder of his high school classmate, a young girl by the name of Haley Lee. He was tried by a jury of his peers, and that jury determines that he was guilty beyond a reasonable doubt. We are here today on the defense's motion to set aside that verdict and order a new trial. The 6th Amendment to the United States Constitution guarantees the right to a fair trial, including the right to be represented by counsel. As Ms. Roca told you, at his original trial, the defendant was represented by counsel who made errors in professional judgments. We concede that her representation fell below the reasonable standard. But as the United States Supreme Court explained in Strickland v. Washington, in order to set aside a verdict based on ineffective assistance of counsel, the defense must prove that counsel's errors were so serious as to deprive the defendants of a fair trial. that means the defense has the burden of proving that, but for counsel's errors, there is a reasonable probability that the outcome of the trial would have been different. And they cannot meet that burden. The evidence today will show that the prosecution's case against the defendant was so overwhelming, counsel's errors did not affect the outcome. Today, you will hear from Morgan Reynolds. She was the defendant's best friend in high school, and she testified at the original trial. She will tell you what she told the jury, that the defendant confessed to killing Miss Lee. She helped the defendant bury Miss Lee's body. Then you will hear from Detective Billie Stoneridge of the Buckeye City Police Department. He will tell you about the evidence they found in the original investigation. He also testified at the original trial, and he will recount to you what he told the jury. That they found a strand of the victim's hair in the trunk of the defendant's car right next to a blue nylon tow rope. And the cause of death? Strangulation. He will also tell you that all of Morgan Reynolds' testimony is corroborated by cell phone data. The focus of inquiry today is whether the outcome of the trial was fundamentally unfair or unreliable. Because that is what the Sixth Amendment is intended to protect, the right to a fair trial. Now, opposing counsel is going to try to distract you with testimony about alibis and location data. But simply establishing that additional evidence could have been presented is not enough to meet their burden that the trial was unfair. At the end of today's hearing, it will be clear that counsel's errors did not affect the outcome, because the evidence against the defendants was so overwhelming. We will request that you deny the defendant's motion because the jury already heard what they needed to hear. Thank you.
Ms. Roca and Ms. Yan, you may call your first witness.
Yes, Your Honor. The defense calls Ms. Randy Johnson to the stand. May I proceed, Your Honor?
May proceed.
Please introduce yourself to the court.
My name is Randy Johnson.
Can you provide us with some background information about yourself?
Of course. Well, I've lived here in Trillium all my life, and I'm actually a teacher where I graduated over at Trillium High School. I've been teaching U.S. history there for the past 28 years now.
So as a teacher, are you involved with any extracurricular activities at the school?
I try. I've never really been all that good at sports, but a couple years back when the field hockey team needed some help, I offered my hand there. It didn't go too well, but last year the kids pulled me into this We the People program. I'm still figuring that one out, but my pride and joy really always has been the after-school homework help program.
What exactly is this after-school homework help program?
It was founded by two other teachers and I 25 years ago. It was when I realized students were having trouble mastering material outside of class when it came to test time. So we made this sort of an after-school kind of thing where students could come in, do their work, or they could get any extra help they needed by any of the available teachers that were there.
Now, Ms. Johnson, can you explain to us your involvement in today's case?
Gosh, it was about 20 years ago when one of my students by the name of Haley Lay was murdered and buried at Olentangy Park. I'm here to talk about the person who was later convicted of that.
Who was that person?
He was another one of the students who went to Trillium. His name was Adam Smith.
For the record, what was the date in which Haley Lay went missing?
I'll never forget. It was in 1998. It was September 18th.
Do you also know what time Haley Lay was murdered?
While I can't be specific about that time, I don't know. I do know that her body was buried at 5 p.m. at Olentangy Park. But see, the thing is, that was the exact time that Adam Smith was with me that day.
Before we get into that specific recollection, did you ever personally know Haley Lay?
Yes, she was in a few of my classes. She was very bright and also very involved in school.
Did you also know Adam Smith?
I did. I actually met him through his aunt, who I went to high school with. And when he was in middle school, she introduced me to him originally. And of course, when he came to Trillium, he did take a few of my classes there.
Now, Ms. Johnson, I want to bring you back to the date of September 18th, 1998. On that day after school, did you see Haley or Adam at all?
While I didn't see Haley that day, I did see Adam.
Where did you see Adam?
I saw him after school at the after-school homework help program.
Can you tell us a little more about your recollections of Adam at the after-school homework help program?
Yes, well, that day was a Friday, and right after school, students began pouring into the classroom. They came in to sign in on the sign-in sheet that was there, and that's when I saw Adam. He came in, and while he was signing in, I remember specifically, we actually joked about having to stop meeting like this at the session.
So aside from that initial conversation you had with Adam, did you have another opportunity to speak with him throughout homework help?
Yes, Adam, it was hard not to, really. He was always the kind of kid, always had his hand up, always asking questions, and that day in particular, he was grilling me on questions about the Civil War.
Was there anything else that happened at homework help relative to Adam Smith?
Yes, well, I had a test in my class coming up that following Monday, as it was a Friday, and I kind of like to challenge my students a little, so it wasn't just Adam asking all the questions, it was pretty much the entire class. So I thought the best thing to do at that point was to split them all up into little study sessions. That's usually the best way to get them to study the most effectively. And when I did so, Adam was in the group closest to my desk.
How long was Adam with you?
He was there until 5 p.m. that day.
Now, Ms. Johnson, these events took place over 18 years ago. So how is it that you still remember Adam was with you attending homework help that day?
It was a traumatic day, really. It was hard after we lost Haley. And the best way to put it is, it's kind of like asking an American where they were when that plane hit on 9/11. You're going to remember something like that.
Now, Ms. Johnson, today the state claims that Adam Smith was at Olentangy Park around 5 p.m. bearing Haley Lay's body. Do you know where Olentangy Park is located?
I do. I've lived here all my life, and I've definitely taken the drive before.
So can you describe that further for us today?
Of course. Well, you see, Trillium High School is located in the northeast section of town, and about due south is where Olentangy Park is located. There's no direct route since there's a bunch of residentials in the area, so if you want to get there, you actually have to go around.
So how long does it take then to travel that distance?
Personally, from the time I leave my classroom, about 30 minutes at least.
Did you ever tell anyone then where Adam Smith and your knowledge of Adam Smith's locations on September 18th, 1998?
Yes. Shortly after Adam was arrested, I spoke with a detective about what happened.
Can you take us through what happened when you spoke with the detective?
Well, of course, we talked about Adam, and then the homework help session came up, and after that, then the sign-in sheet happened to come up. And at that point, I offered to get him a copy of this very sign-in sheet.
Well, how did the detective respond?
He didn't seem interested. He didn't take or accept my
Your Honor,
offer.
speculation as to the defendant's thoughts about the sign-in sheet.
Your Honor, if I may respond?
Go right ahead.
Your Honor, I believe Ms. Johnson is simply telling us today that the detective did not take the sign-in sheet, and as this was an action that she herself perceived, she may provide this opinion as it is a lay opinion pursuant to Rule 701.
Your Honor, Ms. Johnson is testifying that the detective was not interested in the sign-in sheet, and she has no personal knowledge of that, and she's speculating as to his mindset.
I'll overrule the objection.
Yes, Your Honor. Ms. Johnson, can you continue your answer?
Yes. Actually, could you repeat the question?
Of course. So did the detective ever take that sign-in sheet?
He didn't. He didn't seem interested, and he didn't accept my offer before he left the classroom.
So we're here today over the actions of Adam Smith's defense counsel. Did you ever know Adam Smith's defense counsel?
Yes. Her name was Christine Munoz.
Did you ever tell Miss Munoz your knowledge of Adam Smith's whereabouts on September 18th?
I tried.
You said you tried. What do you mean by this?
I called her on multiple occasions, and none of those times did she ever pick up any of my calls.
So did you leave any voice messages then?
I did. I left a few after she didn't return any of my calls.
Did she ever respond to those voice messages?
No, she didn't.
What was the nature of those voice messages then?
In those messages, I said I had information on what Adam might have been doing that day, and I never heard back.
So, Ms. Johnson, has anyone on the behalf of Adam Smith's defense counsel ever once contacted you about the information you had?
I never got an email. I never got a text back. I never got any messages after I had reached out to her. And no one, not Miss Munoz or anyone on her defense counsel, ever reached out to me.
Thank you, Ms. Johnson. No further questions, Your Honor.
Mr. Dingman?
Yes, Your Honor.
May I proceed?
You may.
Ms. Johnson, you said something on direct examination that I found very interesting. You stated that to get to Olentangy Park from Trillium High School, you have to drive around an entire residential area, correct?
From my personal experience, yes.
You remember preparing a sworn affidavit in preparation for today's case?
I do.
And you included all relevant information in that affidavit?
Yes, I do.
Your Honor, let the record reflect I'm showing opposing counsel what has already been stipulated as Ms. Johnson's affidavit.
Record will so reflect.
It's in admission. And may I approach the witness with the same?
May.
Ms. Johnson, I just handed you your affidavit. You recognize this?
Yes, I do.
It's a clean and unmarked copy.
Yes, it is.
It hasn't been altered in any way.
No, it did not.
Nowhere in this affidavit do you state that to get to Olentangy Park, you have to drive around a whole residential area, do you?
I do not. See, the thing is, that's the general area of Trillium High School. I didn't put that in my affidavit, but I do say that it does take at least 30 minutes to get there.
But you did not state that you have to drive around a residential area to get there, did you?
Not those specific words, no.
Your Honor, may I retrieve the affidavit?
You may do so.
Ms. Johnson, you're friends with the defendant's aunt.
40 years ago in high school, we were.
You considered her to be a pretty good friend?
We were pretty good friends in high school, yeah.
In fact, you met the defendant through your relationship with his aunt,
Oh, yes, I did.
and you met the defendant when he was in middle school.
Yes, that is correct.
You promised the defendant's aunt to keep an eye out for him, didn't you?
Oh, yeah. I'm always excited whenever I get a new student to keep under my wing, and as I would any of my students, I did keep an eye out for him.
But you specifically promised the defendant's aunt you'd keep an eye out for him, correct?
Yes,
And you did keep that promise over the years?
as I would any of my students.
Ms. Johnson, you are aware the defendant was convicted of murder in 1999?
Yes, I am aware.
In 1998, you were a teacher at Trillium High School?
I've still been teaching there.
Adam Smith was a student at Trillium High School.
Yes, he was. He took a few of my classes there.
He was convicted of murdering Miss Haley Lee.
Yes, he was later on.
Miss Lee was also a student at Trillium High School.
Yes, she was not only just a student there, but also one of my students.
The defendant was convicted of burying the body at Olentangy Park at 5 p.m. on September 18th, 1998.
To my understanding, yes, that is correct.
But you claim the defendant was with you at homework help on September 18th, 1998 at 5 p.m.
He was with me that day.
And of course, if he was with you, he couldn't have been burying a body at the same time, correct?
Oh, of course not.
I'd like to talk about how well you remember that day. It was almost 20 years ago.
Yes, that is correct.
You ran homework help back then?
I did, and I still do.
Back in 1998, homework help was offered 5 days a week.
Mondays through Fridays, yes.
It was a fairly popular program.
I would say so. Students were really into being able to do their homework before they had to go to school.
So it was a fairly popular program.
Yes.
And this day in question, September 18th, 1998, was no exception, correct?
It was a Friday, so not really.
And you recall students preparing for an upcoming test?
Yes, it was actually one of my tests that I had offered that Monday.
You
the
split them
following
in.
Monday.
Sorry, you split them into small groups.
Study groups. Usually the students are kind of rowdy, so it's the best way to get them to study.
And you put the defendant in a group near your desk?
Yes, he was in the group closest to my desk.
Ms. Johnson, you don't remember anyone else who was in the defendant's group, do you?
No, if I had the sign-in sheet to that day, then I would.
I'm not asking you to speculate as to what you would be able to tell us if you had the sign-in sheet. You don't remember those students, do you?
I do remember Adam, though.
So we can't ask them to corroborate your story?
Back then, during that time, if you had asked anybody that was on that sign-in sheet, they could have.
I'm not asking you to speculate as to what other people would have said.
I'm sorry, mister.
We can't ask them to corroborate your story, can we?
No, not to this day, no.
I'd like to talk a little bit about your timeline. Students normally leave homework help sessions around 4:30 or 4:45.
Could you repeat that?
Students normally leave homework help sessions around 4:30 or 4:45.
It was open, the homework help session was open until 5 o'clock, if that's what you're asking.
Students usually left around 4:30 or 4:45, though, correct?
Oh, on normal days, yes, but I wouldn't say this was a particular usual day, as I had a test that Monday.
You stated they did usually leave, though, correct?
Usually.
But it's your testimony that on this specific day, the defendant stayed until 5 p.m., correct?
Yes, the students were working very hard to prep for this U.S. history test.
So that's a yes?
That is a yes.
You also kept a sign-in sheet to keep an account of all students that showed up to homework help?
I did.
You're required to turn in the sign-in sheet the day after every homework help session.
Yes, the school day after every homework session.
Yes, so you're supposed to turn it in on the next Monday.
Yes.
But it wasn't until a week after that you turned this homework help sheet in. Is that correct?
Yes. Do you realize what we were going through? At the time, we lost Haley that day, and not only was she a vital member to our community, but she was also one of my students, and I had to deal with all of the students who were confused and scared about what had happened.
Ms. Johnson, you didn't turn in that sign-in sheet when you were supposed to, did you?
Not that following Monday. As a teacher, I didn't have any of the answers for the first time for any of these students.
Ms. Johnson, that's a no. You didn't turn it in when you were supposed to?
Not that Monday, but I did turn it in the week after her body turned up.
Now, you don't have that sign-in sheet today, do you?
No, I don't.
You also claim that you spoke to a detective?
Yes, I did, shortly after Adam was arrested.
And you claim that he wasn't interested in what you had to say?
He didn't take my offer, so no.
But you don't remember who that detective was, do you, Ms. Johnson?
No, he left before I could either give him the sign-in sheet.
You also claim that you tried to get in contact with the defendant's attorney?
I tried, yes.
But she never got back to you?
Not once, ever.
Ms. Johnson, it is true, it wasn't until during the trial that you realized the importance of the sign-in sheet, correct?
I realized the importance of what I had seen that day, yes.
But you didn't realize the importance of the sign-in sheet until after the trial had began, correct?
It was during the trial when I realized that, yes, Adam was with me.
Once you realized the importance of the sign-in sheet, you didn't try and obtain a copy from the school for yourself?
No, I had turned it into the school, and of course, I offered it to the detective first.
But after you realized the importance of the sign-in sheet, you didn't try and obtain a copy, did you, Ms. Johnson?
Not for myself, no.
After you realized the importance of the sign-in sheet, you didn't try and give a copy to the court?
I already tried giving a copy to the detective.
After you realized the importance of the sign-in sheet, you didn't try and go to the police department and give a copy to them?
Yes, I spoke with the detective beforehand, yeah.
Besides speaking with the detective, you never took a copy to the police department, did you?
No, he rejected my offer.
After realizing how crucial the sign-in sheet was, you never tried to give it to a local newspaper?
No, I already offered it to a detective on the case. No, I didn't.
Ms. Johnson, you never tried to get in contact with your close friend, the defendant's aunt.
No, not since high school.
Thank you. I have no further questions at this time, Your Honor.
Any redirect?
Yes, Your Honor, briefly. May I proceed, Your Honor?
You may.
So opposing counsel talked to you about those residential areas around Trillium High School and Olentangy Park. Why didn't you include that information in your affidavit?
Well, you see, I've lived in Trillium all my life, and I've taken the drive there before. I didn't think it was necessary to put that in there, as it didn't seem really relevant at the time. But in there, I did state that it takes at least 30 minutes to drive from Trillium High School to Olentangy Park.
Thank you, Your Honor. No further questions.
Any recross? No recross, Your Honor. You may step down. Thank you. Defense, you may call your second witness.
Yes, Your Honor. The defense calls Addison Waranowitz to the stand. May I proceed?
You may.
Please state your name for the record.
Good morning. My name is Addison Waranowitz.
What do you do for a living, Ms. Waranowitz?
Well, currently I teach physics and electrical engineering at Buckeye State University. But for the majority of my career, I have worked as a radio frequency engineer.
What exactly is radio frequency engineering?
Well, it is a specialization within the field of electrical engineering that focuses on the transmission of radio waves from one point to another. This technology also allows radio frequency engineers to help construct cell tower networks.
Is it used for any other purposes?
Yes, ma'am. Its technology, to a certain extent, can be used to find an individual's location.
What qualifications do you have to specialize in that area?
Well, in 1986, I received my degree from the Israel Institute of Technology for electrical engineering. I also have worked for companies like Pelephone and YT&T Wireless, in which I helped design and construct cell tower networks. I also have a total of 27 years of experience in the field of electrical engineering.
Have you ever testified before as an expert in the area of radio frequency engineering?
Yes, I have on multiple occasions. I have testified for both the prosecution and defense teams. I also testified on behalf of the state during the original Adam Smith murder trial.
Your Honor, at this point, pursuant to Rule 702, we ask the court to recognize Addison Waranowitz as an expert in the area of radio frequency engineering.
Your response?
Your Honor, this witness has been retired since 2013, and any knowledge she has of the area in radio frequency engineering is far outdated as of today.
May I respond, Your Honor?
You may.
With all due respect to opposing counsel, Ms. Waranowitz has laid sufficient foundation as to her degrees in the area, as well as her about 27 years of experience in the field. Regardless of her retirement, she is more than qualified to testify as to the critical components of radio frequency engineering in today's case, especially relevant as she testified in the original trial, and she would be familiar with the data that was present.
Your Honor, this witness retired in 2013. Radio frequency engineering has had revolution in that 6 years, and she cannot be qualified to testify as an expert witness due to those advancements.
May I respond, Your Honor?
You should know the advancements.
I would be well aware, I would suppose so, Your Honor, as she has had years of experience and has she already laid out that she teaches in this area as well and related areas to the field, and she keeps up with this technology as she's already laid in her qualifications.
The threshold for her to be recognized as an expert has been met. The objection is overruled.
Yes, Your Honor.
Go right ahead.
Ms. Waranowitz, could you explain to the court what your involvement is in today's case?
Certainly. I am here to first address the limited scope of my original opinion I offered at the first trial, and second, to determine whether cell phone data can place Adam Smith at other locations, such as Trillium High School, specifically talking about the day of September 18th, 1998.
Your Honor, permission to approach the witness with copies of exhibits A, B, and C.
You may do so.
Would the court require courtesy copies of the exhibits?
I believe we have copies.
Yes, Your Honor. Let the record reflect, I'm showing opposing counsel clean and unmarked copies of the exhibits.
Thank you.
Ms. Waranowitz, could you identify those documents?
Certainly. These are the documents I used in my analysis. Exhibit A is a copy of my own tower proximity reports that I conducted in 1998 as well as in 2017. Exhibit B is a copy of the call detail record for Adam Smith, specifically regarding his incoming and outgoing calls made on September 18th. And Exhibit C is a copy of the relevant cell towers I used in my analysis.
Your Honor, there is a stipulation that all exhibits have already been admitted into evidence. May I proceed?
You may.
Ms. Waranowitz, could you explain to the court how the defendant's cell phone data in this case was generated?
Certainly. Well, in order to understand how this data is generated, we first have to understand the basis of radio frequency engineer. Every time you send a text message or you make a phone call, essentially anytime you use your phone, it emits a radio frequency wave and it pings a tower. And it continues to ping a tower until it reaches its end destination. That information is then recorded onto a user's call detail record.
Well, how does knowing which cell tower is accessed help you identify location?
Well, as I just mentioned, this information is recorded, and as you can see in Exhibit B, there is a multitude of information. For example, there is the number dialed, the call time, the call duration, as well as the cell site. So to answer your question, Counselor, the cell site ultimately tells us where an individual is located.
What do you mean by where?
Well, you see, rather I explain it in technical terms, allow me to break it down. If you look to Exhibit C, specifically the bottom section of this exhibit, you can see that there's a circle. This describes the coverage area of a tower. Now, in the center, that is the tower, and it is cut into 3 pieces. Each piece is referred to as a side, and the side encompasses its own coverage area that we refer to as a sector. Now, the sector is incredibly broad, but it allows us to determine where in that broad area an individual is located.
You said broad area. Just how big is one of those sectors?
Well, a sector has a central angle of about 130 degrees, and it has a range of 10 miles. So the area of the sector is over 100 square miles.
Given that size, could you provide the court with an example of how location can actually be determined?
Absolutely. Let us look to a time relevant to today's case. If you look to Exhibit B, specifically line 5, there is an incoming call at 3:47 p.m. You can see that this call specifically pinged tower N653A. Now, using this information, we can go to the cell tower map. We can see that tower N653 is located towards the northern section of the map. And because we know it pinged side A, that tells us that the user was in the northwest by northeast section of town, or specifically the northwest by northeast section of that specific side.
Ms. Waranowitz, for clarification purposes, where is that sector in relation to the Reynolds residence?
Well, going back to the map, you can see that the Reynolds residence is on the opposite side of that tower.
Now, how's it determined which of those towers gets pinged?
Well, theory suggests that it would ping the closest tower, but in practice, this is not always the case. There are a host of variables that can affect where a radio frequency wave bounces and whether it changes its direction.
Well, what are those variables?
I personally like to refer to them through the acronym of towns, and I frequently use this acronym as well. It's referred to as topography, obstructions, weather, number of users, and signal strength. Any one of these variables can affect where that signal bounces.
Well, given those variables and that broad size, how precise is this science?
That's the problem, Counselor. It's an inexact science. It is not like GPS data that uses triangulation methods to pinpoint an individual's location. Rather, it gives us the general area that a user is located in a relatively large sector.
Well, earlier you mentioned that you gave an opinion based off the science at the original trial. What was that opinion?
Well, my opinion at the original trial was that Adam Smith's movements corroborated the testimony of Morgan Reynolds.
What did you mean by corroborated?
Well, you see, 1998 was the first time I had provided expert testimony in a criminal investigation, and the state had only provided me a small, specific list of locations that I personally was supposed to test. So to me, all this meant was whether the locations were possible based off the science, and to my knowledge, they were.
Well, in cross-examination, did defense counsel ever address that your opinion merely indicated a possibility?
No, ma'am, they did not.
Well, did defense counsel ever address the precision of cell tower data?
Absolutely not. They did not ask any questions regarding the actual science and precision of the data.
So then, what was the nature of your cross-examination?
It consisted of 5 questions, one regarding whether I was being paid for my expert testimony, and the others regarding my immigrant status.
Well, as that was the testimony you elicited at the original trial, I'd like to talk about your opinion for today. How did you go about your analysis for today's trial, today's hearing?
Well, it was essentially the same type of analysis. All I did was conduct an additional drive test to determine whether the call placed at 4:58 p.m., which pinged tower L655A, could have originated from Trillium High School.
How would you conduct that drive test?
Well, in drive tests, we determine whether a cell phone can ping a certain tower. So we drive around town from different locations and attempt to see whether that cell phone can actually ping that tower.
And what did your test reveal?
Well, if you look to Exhibit A, specifically lines 3 and 4, these tests refer to my results from Trillium High School. If you look at line 4 specifically, my tests reveal that tower L655 can be pinged from Trillium High School.
Given these results, were you able to form an opinion as to Adam's potential whereabouts around 5 p.m. on September 18th?
Yes, ma'am.
When forming that opinion, did you use generally accepted principles in your field of expertise?
Absolutely.
And is that opinion to a reasonable degree of professional certainty?
Yes, ma'am.
Ms. Waranowitz, what is your opinion?
My opinion is that based off my results, Adam Smith could have been at Trillium High School on September 18th, 1998 at around 5 p.m.
Could you be any more precise about that opinion?
See, Counselor, that's the problem with this type of science. It is not possible for us to be any more scientifically accurate about this type of data. Adam Smith could have been at any one of the locations serviced by side A of the tower. He could have been at Trillium High School. In fact, he could have been at Olentangy Park. We cannot tell specifically in that sector where he was located.
Thank you, Ms. Waranowitz. Your Honor, no further questions.
Ms. Osborne, you may cross-examine the witness.
Yes, Your Honor. May I proceed?
You may.
Let's begin by talking about the trial that occurred in 1999, specifically your role in that trial. You testified as an expert witness?
I did. That is correct.
You testified on behalf of the state?
Yes.
You were asked to determine if the state's eyewitness could be corroborated by the cell phone data, correct?
I basically determined whether Adam Smith's movements could be corroborated by Morgan Reynolds' testimony.
And you concluded that the cell phone data corroborated Morgan Reynolds' testimony, didn't you?
That is correct. However, there were other parts of the science that I was unable to explain at the trial.
That's a yes to my question?
Yes, ma'am.
Let's talk about the data. I believe you have a copy of Exhibits B and C in front of you.
I do.
Exhibit B is Adam Smith's call detail record from September 18th, 1998.
That is correct.
It shows the incoming and outgoing calls.
That is absolutely correct, Counselor.
The call time.
Yes, ma'am.
The call duration.
Yes.
And the cell phone tower where the call originated.
Absolutely.
In order for a cell phone to connect to a tower, it must send and receive signals, right?
That is absolutely correct. And the tower receives that signal, and cell phone companies record all this information to what you just referred to.
And this is called a ping?
Yes.
Now, you also have a copy of Exhibit C,
Yes, I do.
and this is a map of the cell tower locations relevant to your analysis.
That is correct.
And these are an accurate depiction of the cell tower locations as of September 18, 1998.
That is correct, and there's also a scale provided allowing me to refer to how far apart these towers are in relation to other locations.
Trillium High School is located in the northeast quadrant of the map, correct?
That is correct. It is located at that northeast part of town.
And it is within about 3 to 4 miles of 2 towers, right?
That is correct. That is Tower N653 and Tower M654.
From 8:45 a.m. until 3:47 p.m., the defendant's phone calls pinged one of these 2 towers, didn't it?
That is absolutely correct. This information is on Exhibit B, and specifically it's referring to lines 1, 2, 3, and 4.
Directing your attention to Exhibit B, a call was placed, call number 6, at 4:58 p.m.
That is absolutely correct, and it pinged Tower M653.
The call placed at 4:58 p.m.
Oh, excuse
pings
me.
Tower L655A,
Yes,
correct?
that is correct. It pinged Tower L655A.
You reviewed Morgan Reynolds' testimony in preparation for today's trial?
I did, and I did determine whether Adam Smith's movements corroborated that testimony.
And she testified that they buried Miss Lee's body at 5 p.m. on September 18, 1998.
Well, I don't know the specifics of the entire testimony. All I know is that that 5 p.m. time frame was significantly relevant.
You did review her testimony, right?
I did.
Directing your attention to Exhibit C, Tower L655, where that phone pinged, is about 2 miles from Olentangy Park, isn't it?
It is. Tower L655 is located towards the southern section of the map, the southeastern, to be specific.
Miss Waranowitz, this tower is about 2 miles from the burial site, isn't it?
I believe it is approximately 2 miles from the burial site, yes.
And from this data, you concluded that Mr. Smith could have been at Olentangy Park at 5 p.m. on September 18, 1998, correct?
Yes, the science allowed me to determine that he could have been at Olentangy Park, but as I just mentioned in my testimony, he also could have been at Trillium High School.
So that's a yes to my question?
Yes, ma'am.
Now, you also conducted a drive test in preparation for today's trial.
That is correct.
I believe you have a copy of Exhibit A?
Yes, I do.
You conducted this drive test 2 times, once in 1998.
That is absolutely correct, and these were based off locations provided to me by the state.
And again in 2017.
Yes, and these are locations similar to the ones that I conducted in 1998.
I'd like to begin by talking about the drive test that you conducted in 1998. You conducted 6 tests.
Yes, that is correct.
And you reported the quality of service for each of those tests.
Yes, this was additional information provided by the results of my test.
Quality of service is basically a measurement of signal strength, isn't it?
That is absolutely correct.
And for each of these tests, the signal strength was in between 40 and 90%, correct?
Yes, that is correct.
And this is what the jury was told, right?
Well, I wasn't cross-examined about the science of this type of data.
You were direct examined, weren't you?
That is correct.
And this is what the jury was told. It was between 40 and 90%, right?
Absolutely.
You never testified that this data told you that Mr. Smith's phone pinged any of these particular towers, did you?
Well, the data indicates by the tower target that is listed in Exhibit A that this tower can be pinged from the particular location.
But you never testified that Mr. Smith's phone definitely pinged one of these towers, did you?
Well, the data indicates that the phone can ping one of these towers.
But you never testified that it was a certainty, did you?
It is a possibility.
So that's a no, you never testified to that?
Not specifically.
You never testified that it was likely that Mr. Smith's phone pinged one of these towers, did you?
Well, as I mentioned before, it is a possibility.
But you never testified that this data told you it was likely that Mr. Smith's phone pinged any of these towers, did you?
Well, you see, Counselor, because this is an inexact science, we cannot use affirmative statements to specify exactly what we're looking at. We can only use terms like possibly to confirm what you are trying to say.
Exactly, Ms. Waranowitz, and you never used any affirmative statements at the original trial, did you?
Well, I did say that the testimony corroborated the movements of Morgan Reynolds.
So that's a no to my question?
That is a no, yes.
Now, directing your attention to the drive test that you conducted in 2017, you performed 7 tests?
I did, and Trillium High School was an additional test that I incorporated.
Now, you utilized the same equipment in this 2017 drive test that you utilized in 1998, didn't you?
Well, yes, I used equipment similar to the test that I did conduct in 1998, and I also attempted to conduct these tests with similar weather conditions to the original tests.
Mr. Reynolds, in this nearly 20
My
years...
name is Ms. Waranowitz,
Excuse me, Ms.
Counselor.
Waranowitz. In this nearly 20 years, YTT Towers has updated their towers, haven't they?
Well, I would say so. Technology has significantly evolved.
Buildings have been constructed.
Absolutely.
Trees have grown.
You could say, but it does take a significant amount of time for trees to grow.
So you couldn't completely replicate the factors that we had in 1998 in this 2017 drive test, could you?
Well, like I explained to you earlier, I attempted to eliminate as many variables as possible. For example, I conducted it with similar weather conditions, and I also used the same equipment that I used in my test in 1998.
So that's a no to my question. You could not completely replicate the factors, could you?
That is correct. I cannot replicate the number of users, tower load. This is all stuff that is humanly out of my control.
Ms. Waranowitz, when you testified in the original trial, you knew the results of your testing could place the defendant in multiple locations, right?
Yes, this is what the science actually tells us, that we cannot specify where in a large area an individual is located.
You didn't lie about this, did you?
Absolutely not. I just did not have the ability to relay this information during my testimony.
In fact, Ms. Waranowitz, you were never asked to give a conclusion to a reasonable degree of scientific certainty as to the defendant's exact location, were you?
No, I was unable to because I was not cross-examined about the I was not able to even address the limited scope of the science. And
Ms. Waranowitz, directing you back to the original question, you never reached a conclusion to a reasonable degree of scientific certainty as to the defendant's exact location, did you?
Unfortunately, no.
You were never asked his exact location, not by the defense.
No, I was not.
And not by the prosecution, were you?
No.
Thank you. I have no further questions at this time.
Ms. Roca?
No redirect, Your Honor.
Okay. You may step down.
Thank you.
Is the defense resting at this time?
Yes, Your Honor, the defense rests.
Prosecution, you may call your first witness.
Yes, Your Honor. The state calls Morgan Reynolds. Please state your name for the court.
My name is Morgan Reynolds.
How old are you, Miss Reynolds?
I'm 38 years old.
What do you do for a living?
I used to work in the pharmaceutical industry, but unfortunately I'm in between jobs right now.
I'd like to be very upfront with the court about your past. Why are you in between jobs?
I got into some trouble with the law back when I was in high school. It's been a long time, but I guess you never stop paying the price. And my boss recently found out about it and fired me.
You said you got in trouble with the law. What do you mean by that?
I was charged with possession of cocaine and carrying a concealed weapon back in 1998, and later tampering with evidence and abuse of corpse.
Were you convicted?
I pled guilty to possession of cocaine and tampering with evidence. The prosecutor offered to recommend probation if I were to testify at Adam's trial.
Directing your attention to this case, are you familiar with the defendant?
Yes, Adam and I grew up together. We went to school together and we were best friends.
Where did you go to school?
We went to Trillium High School.
What years was this?
1995 to 1999.
You said you testified at the original trial. Do you remember who the victim was?
It was Adam's ex-girlfriend, Haley Lee. She went to Trillium with us.
I'd like to talk about what you told the jury in that original trial. Do you recall what you told them?
I do. It's been a long time, but I can remember the big picture.
Did you talk about September 18th, 1998?
I did.
How did that day begin?
Like normal, I guess. I got up, went to school, started off like a typical day.
How did you get to school?
Adam picked me up.
Was this a normal routine?
Yeah, it was.
Do you recall what car the defendant was driving?
He was driving his white Oldsmobile Alero that he'd gotten for his birthday the year before.
Did anything unusual happen once you arrived at school?
Well, I remember Adam wasn't really acting like himself, but it was nothing that I could really put a finger on. And I remember he'd mentioned that he and Haley had been fighting and that they broke up, but I didn't think anything of it at the time.
Did anything unusual happen throughout the school day?
Well, Adam didn't show up to lunch in the cafeteria, which I remember thinking was strange, so I called him to see where he was, but he never answered.
Miss Reynolds, in 1998, did you have a cell phone?
No, but Adam did. I called him from the payphone in the cafeteria.
Did you normally see the defendant after school?
Yeah, normally after school I'd go to the library until about 3:30, and Adam would go to homework help. And then after I was done in the library, I'd go to the homework help classroom to see what time Adam was planning on leaving, and if we were leaving around the same time, he'd take me home.
Did you see the defendant after school that day on September 18th, 1998?
No, I went to the homework help classroom, but I didn't see Adam there.
Did you ever find out where he was?
Well, I remember thinking it was strange that I didn't see him at homework help, so I went to the school office to call him to see where he was. And he picked up and said that he was at my house and that I needed to come home right away.
Did you do that?
I did.
What happened once you arrived at home?
Well, we got home around 4:15, and Adam was there waiting for me. And he looked at me and said that he had killed Haley and that he needed my help.
Miss Reynolds, did the defendant ever show you Miss Lee's body?
Yeah, he went out to his car and opened the trunk, and there was a big bag inside. And he started to unzip it, and Haley's body was inside.
You said the defendant needed your help. What did he ask you to do?
He told me to get shovels and to get in the car.
Did you do that?
Yes.
What happened once you got in the car?
I remember him asking about parks and secluded hiking trails, and he drove to Olentangy Park, and there are a lot of secluded areas there.
Miss Reynolds, why did you help the defendant?
Because I was scared. Adam threatened me. He threatened my family. My family had done some things that I'm not proud about, and I didn't know what he was capable of, so I didn't know what else to do.
Do you recall about what time you arrived at Olentangy Park?
It was around 5 when we got there.
And what happened once you arrived?
We got out of the car, and Adam told me to grab the shovels, and he started walking off into the woods. So I got the shovels and followed him, and we walked for a while, and Eventually he stopped and started digging, so I started digging too. And then we walked back to the car and got her body out of the trunk and walked it back to the hole and buried her. And it's haunted me every day since.
Thank you, Ms. Reynolds. I have no further questions at this time.
Any cross-examination?
Yes, Your Honor. May I proceed?
You may.
Ms. Reynolds, my name is Elizabeth Roca, and today I'll be asking you a couple questions on behalf of the defense. Will you be able to proceed?
I will.
All right. Now, there's something about what you said on your direct examination that I found as strange. I'd like to clarify it. Now, you said you called Adam sometime between 3:30 and 4 p.m., correct?
I did.
You placed that call. You said you were at Trillium High School.
I was at school.
And you also told us that when you placed that call, Adam was at your house.
That's what he had said.
And that's what you testified to at the original trial?
Yes.
But that statement, Ms. Reynolds, isn't that statement a lie?
What statement exactly?
The statement that Adam Smith was at your house. Isn't that a lie?
No.
Well, didn't defense counsel at the original trial ever cross-examine you about the inconsistency between your testimony and the cell phone data?
No.
Oh, so you're not aware that the defendant's cell phone data actually places him in the opposite direction of your house?
Objection, Your Honor. Lack of personal knowledge. This witness has no reason to know anything about the cell phone data and lacks the expertise to draw any conclusions from it.
May I respond, Your Honor?
You may.
Ms. Waranowitz has already testified today that the cell phone data places Adam Smith in the opposite direction of Ms. Reynolds' home. And this question, however, is not asking Ms. Reynolds to interpret any data. It's simply asking her if she's aware that the data places him in the opposite direction, which she would have been if she were cross-examined about it. I'm simply asking her to answer this question to her rational-based perceptions pursuant to Rule 701, as she may testify to as she is a lay witness.
Your Honor, if I may respond, the witnesses in today's trial are constructively sequestered, and this witness has no knowledge of the cell phone data and therefore cannot testify about its contents.
May I respond, Your Honor?
You may.
The witness, however, would have personal knowledge as to what she was cross-examined on in the original trial. If she was cross-examined on it, she would certainly be aware of that inconsistency. The question in and of its nature simply asks Ms. Reynolds if she's aware of that inconsistency.
You're asking her to testify based on either the trial transcript, which is not in evidence from the prior trial, or as to the testimony of another witness. I agree the witnesses are constructively sequestered. The objection is sustained.
Yes, Your Honor. Ms. Reynolds, I'd like to talk about how you ended up testifying at the original trial. Now, you indicate on direct examination that in 1998, you were charged with possession of cocaine.
I was.
You're charged with carrying a concealed weapon.
Yes.
Now, when you were charged with those crimes, you told your attorney everything you knew about Adam's case.
Yes, at that point I felt that it was safe to come forward.
And the one condition you had for that testimony was to tell the truth.
It was.
The fact of the matter is, when you first went to the police, you started off with an elaborate lie, didn't you?
I wouldn't call it elaborate. I said that Adam told me that he'd killed Haley. I said that we went to Olentangy Park, but I did say that he showed me Haley's body at Cardinal Park in order to keep the police away from my house to protect my family.
Well, I'd like to break that testimony down bit by bit. Now, what you actually told the police is that instead of going to Olentangy Park first, you first went to Cardinal Park, correct?
That's right.
And you told the police it was at Cardinal Park you started to get cold feet.
I mean, I guess so, but there wasn't really an option at that point.
Bringing you back to the original question, did you or did you not tell the police it was at Cardinal Park that you started to get cold feet?
I did tell them that.
And you told them at Cardinal Park it was that time that Adam showed you the body of Haley Lay.
That's correct, and it's Haley Lee.
But the fact of the matter is, all of that was a lie, wasn't it?
Right, we didn't go to Cardinal Park, but I said that to keep them away from my house because I didn't want my family involved.
Right, the reason why you told this lie was, as you said, to protect your family, correct?
That's right.
You wanted to protect them from going to prison.
That's right.
But the fact of the matter is, Ms. Reynolds, it was you who was facing the prospect of going to prison when you lied to the police, wasn't it?
Yes, at that time I was 18 years old and didn't realize the seriousness of what I had just done.
So bringing you back to the original question, when you told that lie, you were the one who was facing the prospect of going to prison.
Yes, I don't think I fully realized how horrible of a mistake that was, but yes.
I'd like to talk about the story you now told this court today. Now, you said something on direct examination. In fact, I wrote this down. You told us today that Adam told you to get shovels and get into that car. Did I restate that correctly?
Yes.
Said you were on the way to Olentangy Park. That's what you said today?
Yes.
So the fact of the matter is, you grabbed the shovels.
I did.
You put them in Adam's trunk.
I did.
You closed that trunk.
Yes.
Then you went around to the side of the door and you opened the car door.
The car door was already open.
Right? Then you sat in that car.
I did.
So, Ms. Reynolds, are you aware that not a single one of your DNA evidence was found in the defendant's car?
Objection, Your Honor. Lack of personal knowledge. Again, this witness would have no way of knowing whether or not her fingerprints were found on the car.
May I respond, Your Honor?
Yes.
I'm simply asking Ms. Reynolds if she's aware of that fact, not to testify if there was any, but simply if she's aware, as she would have if she were cross-examined at the original trial.
Objection is sustained.
Yes, Your Honor. Now, Ms. Reynolds, the reason why you told this story in the first place was to cut a plea deal, correct?
Well, no, I told the story to finally get it off my chest. I felt that it was safe at that point to tell someone what I knew.
Well, actually, when you first went to your attorney, you went with the hopes that that information you told her would help you out in your own case.
I thought that maybe it might help, but the reason that I told them what I knew was to finally get it off my chest. After all that time, I felt that it was safe.
Well, Ms. Reynolds, didn't you state in prior sworn testimony that you went to your attorney with the hopes that it would help you out in your own case?
Right, like I said, I thought that it might help, but that wasn't the main reason that I told them what I knew.
The fact of the matter is, it did help you in your case, didn't it?
Objection,
so.
Your Honor. Lack of personal knowledge as to how this affected the outcome of her case.
May I respond, Your Honor?
You may.
Ms. Reynolds would certainly be aware of how the plea deal affected any of the dropped charges or any reduced sentence she might have had as a result of that plea deal. That's all the question is simply asking of this witness. She would be well aware of that pursuant to her rationally based perceptions under Rule 701.
Your Honor, this witness is not aware of the mindset of the prosecuting attorney and what her testimony, how it impacted her charges.
She's aware of whether it helped her. I'll overrule the objection.
Yes, Your Honor. The fact of the matter is, Ms. Reynolds, that plea deal, or the testimony you gave your attorney did in fact help you in your own case, didn't it?
I guess you could say that.
The fact of the matter is, when you first cut that plea deal, you were sentenced 3 years of probation, weren't you?
Yes, I was.
Then you testified at Adam's trial in 1999.
I did.
Then you went back into court in 2000.
Yes.
And when you went back into the court, your plea deal had diminished your probation from 3 years to 1 year, didn't it?
Yes, and I was speechless.
Thank you, Ms. Reynolds. Your Honor, no further questions.
Any redirect?
Yes, briefly, Your Honor. Ms. Reynolds, were you ever dishonest about what the defendant told you on September 18th, 1998?
No. I told the jury and I told the police that Adam said that he killed Haley. I said that we went to Olentangy Park, and I said that we buried her body.
Thank you. I have no further questions.
Any recross?
No recross, Your Honor.
You can step down. With my deepest apology to the bailiff, I believe I did not have you swear in the witnesses. So you're going to get to do it twice. So we'll have the witnesses who've already testified, and you're going to ask them whether they are testified truthfully, and then the last witness, you'll testify if she swears that the testimony will be the truth. So the three witnesses who have testified, if you'd step up.
Please raise your right hand. Do you solemnly swear that the testimony that you have already given is the truth, the whole truth, and nothing but the truth, and the testimony that you gave complied with the rules of the Ohio mock trial competition?
I do.
You may be seated.
Now we'll call your one remaining witness up. I don't think his team
swear
does.
that the
I don't
testimony
believe his
you're
team
about to
does.
give is the truth, the whole truth, and nothing but the truth, and your testimony will comply with the Ohio mock trial competition rules? I do.
Again, to the bailiff, you have my apology. I don't know if you were introduced. Were you introduced? Could you introduce your...
My name is Austin Tyree.
Okay, thank you very much. Now, sorry for the interruption. You may call your next witness.
Yes, Your Honor, the state calls Detective Billie Stoneridge. May I proceed?
You may.
Please introduce yourself to the court.
Good morning. I'm Detective Billie Stoneridge.
What do you do for a living, Detective Stoneridge?
I'm a detective in the homicide unit of the Buckeye City Police Department.
How long have you worked for the Buckeye City Police Department?
29 years, sir.
Have you always been in homicide?
No, sir. I began my career as a patrolman when I graduated from the State Police Academy in 1989. I was then promoted to detective in 1996, and I began my career in the Missing Persons Unit. I then moved to homicide in 98.
Have you received any additional training throughout your career as a detective?
Yes, sir. I completed a formal training as a state investigator, as well as an advanced criminology training in forensic science at the FBI Academy in Quantico, Virginia. And of course, I've had on-the-job training with many other seasoned detectives over the course of my career.
Are you familiar with the defendant in today's case, Adam Smith?
Yes, sir. I was involved in the murder investigation which led to his conviction.
How did you become involved in the investigation?
Well, a high school student by the name of Haley Lee was reported missing on September 18th, 1998. As I mentioned, I was in the Missing Persons Unit at the time, so I was assigned to investigate. I then remained on the case after it became a murder investigation.
Did you testify in the defendant's original murder trial?
Yes, sir, I did.
I'd like to talk about the evidence you presented to the jury in that trial. Did you testify as to the relationship between the defendant and the victim, Ms. Haley Lee?
Yes, sir. I told the jury that I had received conflicting reports about the relationship.
Your Honor, no statements have been offered as to what these conflicting reports are.
Your Honor, may I respond?
Yes.
Your Honor, these reports, opposing counsel has not laid the foundation of where these reports came from or the source of these reports. Therefore, we do not know if these reports are based upon hearsay or not.
May I hear your question again?
Did you testify as to the relationship between the defendant and the victim?
Objection is sustained.
Yes, Your Honor.
Detective Stoneridge, did you learn anything about the relationship between the defendant and the victim, Ms. Haley Lee?
Yes, sir. After I interviewed two students at Trillium High School, Rosie Udall and Janie Williams, I gained information on the relationship between the two.
Objection, Your Honor. Hearsay again.
Your Honor, may I respond?
Yes.
These statements are not being offered to show the relationship between the defendant and the victim, Ms. Haley Lee. As the United States Supreme Court explained in Strickland v. Washington, a court hearing an ineffectiveness claim must take into consideration the totality of the evidence presented to the jury in the original trial. Detective Stoneridge testified that he presented this to the jury in the original trial. Therefore, it's not this court's role to determine whether or not the underlying facts are true or false, and therefore we are not offering them for their truth value. Therefore, since they're not being offered for the truth of the matter asserted, they are not hearsay.
Your Honor, if I may respond?
Yes.
Your Honor, we do recognize the Supreme Court's ruling in the Strickland v. Washington case on page 148. But if you turn to the next page, on page 149, the Supreme Court has established that these rules are not mechanical rules and are not set standards. In addition, the Supreme Court has also stated in the same Strickland case that opposing counsel brings up that today the ultimate focus is on a fundamentally fair trial. Because in today's hearing, we do not have access to these trial transcripts, we have no way of knowing what information was objected to at the time of the original murder trial, and in addition, we also have no knowledge as to what information was admitted. As a result, we believe that this still should be subjected to the evidentiary hearing rules in regards to hearsay testimony.
And I agree. Objection is sustained.
Yes, Your Honor.
Yes, Your Honor.
Detective Stoneridge, did you testify as to whether or not the defendant and the victim, Miss Haley Lee, or where the defendant was the afternoon Miss Lee went missing?
Well, again, sir, I told the jury that I had received conflicting reports.
What were these conflicting reports?
There were witnesses who claimed to have seen the defendant immediately after school with the victim, but again...
Your Honor, again, I would like to renew my hearsay objection in recognition of the court's prior ruling and to strike the statements made by Detective Stoneridge.
Your Honor, I'd like to remind the court that we are not here today for guilt or innocence. We are here to determine whether or not a new trial should be granted. In determining this, we must take into consideration the totality of the evidence presented to the jury in the original trial.
Your Honor, I stand by my previous response to opposing counsel's citation of the Strickland v. Washington case in regards to our lack of access of the trial transcripts and us not knowing what information was ultimately admitted at that time of the original trial.
Any response?
Nothing further, Your Honor.
Objection is sustained.
Yes,
Your argument, as I understand it, counter to the defense motion, is that the evidence is so overwhelming of the defendant's guilt that there's no prejudice, correct?
Yes, Your Honor.
So you can introduce that evidence, but you can't introduce testimony as to what was testified to at the trial.
Yes, Your Honor.
Okay.
Detective Stoneridge, I'd like to talk a little bit about your investigation. Did you pursue any leads as to where the defendant was the afternoon Miss Lee went missing?
Yes, of course, sir.
Did you present those leads to the jury?
Yes, sir. I presented 3 independent sources of information to the jury, placing the defendant at the victim's burial site.
What were these sources of information?
Well, first, we had disinterested eyewitnesses who reported seeing the defendant's vehicle at the scene, a 1997 white Oldsmobile. Second, we had a witness who reported helping the defendant.
Your Honor, I again would like to renew my hearsay objection, and I ask, may I also have a continuing hearsay objection in regards to additional testimony of the similar nature and like when it comes to hearsay?
Your response?
Yes, Your Honor. This testimony is being offered to show the subsequent actions of the detective as well as the testimony that was presented to the jury in the original trial.
But this is not a motion to suppress. What is not an issue in this case is why the defendant acted in the way he did. The issue is whether the deficient representation of counsel prejudiced the defendant. And in that regard, certainly you can argue that or present evidence that the evidence is so overwhelming that the result would not have been different. Or you can present evidence that countering the defense evidence, but what you can't do is testify to what hearsay essentially from the prior trial.
Yes, Your Honor.
Okay. I hope that's helpful.
Yes, Your Honor. Detective Stoneridge, did you ever have an occasion to search the defendant's vehicle?
Yes, sir. We obtained a search warrant on September 28th, 1998. I executed that warrant at 1100 hours.
Did you document your findings?
Yes, sir. I documented all my findings in the evidence collection log.
Would you recognize this evidence collection log if it were presented to you today?
Yes, sir. I'm sure I would.
Your Honor, let the record reflect I'm showing opposing counsel what has already been admitted into evidence as Exhibit E. May I approach the witness with the same?
You may do so.
Detective Stoneridge, do you recognize what I've just handed you?
Yes, sir. This is the evidence collection log associated with the murder investigation.
Was this evidence collection log presented to the jury in the original trial?
Yes, sir, it was.
Has it been altered in any way?
No, sir.
Was anything of interest found in the defendant's vehicle?
Yes, sir. We discovered a blue nylon tow rope, item 001 on the evidence collection log.
Where did you find this blue nylon tow rope?
It was in the trunk of the car, sir.
Did you explain the significance of the rope to the jury?
Yes, sir. I presented the coroner's report to the jury, which showed the cause of death is strangulation with a cord or a rope.
Was anything else of interest found in the defendant's vehicle?
Yes, sir. We also discovered 6 strands of hair, brown in color, 6.5 to 7.25 inches in length. It's item 006 on the evidence collection log.
Where was this hair found?
It was in the trunk of the car, sir. It adhered to the fabric lining above the left side tail light.
Did you have the hair analyzed?
Yes, sir. And it was a match to the victim, Ms. Haley Lee.
Did the defendant offer an explanation as to why the victim's hair was found in his trunk?
Yes, sir, he did.
Was this explanation presented to the jury in the original trial?
Yes, sir.
What was his explanation?
The defendant claimed at a picnic the previous summer that the victim accidentally slipped and fell into the open trunk of his car.
Did the defendant offer an explanation as to why a blue nylon tow rope was found in his trunk?
Yes, sir, he did.
Was this explanation presented to the jury in the original trial?
Yes, sir.
What was his explanation?
The defendant claimed it was part of an emergency roadside kit, including jumper cables, flares, and a disposable camera.
Detective Stoneridge, were jumper cables, flares, or a disposable camera found in the defendant's vehicle?
No, sir. Only the rope.
Thank you. I have no further questions at this time, Your Honor.
Any cross-examination?
Yes, Your Honor. May I proceed?
You may.
So, Detective Stoneridge, back in 1998, as an officer, you were good at what you did, correct?
Yes, ma'am. To this date, I have 29 years of experience.
So you made sure that whenever conducting investigations, you were very thorough, right?
That's correct, of course.
So next, I want to just take us through this chronologically, starting with when Haley Lay's body was discovered buried at Olentangy Park. So her body was found at the park on September 25th, 1998, correct?
Yes, ma'am, in a shallow grave.
Now, Detective Stoneridge, the coroner, could only give an estimate as to the date of her death. Isn't that right?
Yes, ma'am. Yes, ma'am. And this estimate was September 18th, 1998.
On top of that, the coroner couldn't give you a specific time in which Haley Lay had been killed. Isn't that right?
No, ma'am.
So after this, you decided to search Adam Smith's car, didn't you?
Well, after we had received testimony from the fisherman who claimed to have seen the
Objection,
defendant's...
Your Honor. Move to strike this portion of the witness's testimony as in regards to hearsay.
Your Honor, again, this was presented to the jury in the original trial, and it's being offered to show the subsequent actions of the detective. Ms. Yan is questioning what Detective Stoneridge did throughout his investigation, and he is simply stating what information he got to further his investigation.
Let's go back a moment. Let me hear your question again.
I asked the detective if after he discovered these reports from the coroner as to the date and time of her death, if he searched Adam Smith's car next.
Your Honor, may I respond?
Yes.
Opposing counsel opened the door to this testimony. As she asked about Detective Stoneridge's investigation, he did obtain this knowledge throughout his investigation in this testimony, and therefore she opened the door for him to testify to it.
The answer has to be responsive to the question that was asked. So I will overrule your objection. Go right ahead.
Thank you, Your Honor. So Detective Stoneridge, you searched Adam Smith's car, correct?
Yes, ma'am, that's correct.
So when you searched Adam Smith's car, again, you made sure to pay attention to all the details, right?
Yes, ma'am, of course.
So there are 3 pieces of evidence that you talked about during direct examination, and I want to go over them one by one. So first, you talked about Haley Lay's fingerprints that you found in Adam Smith's car, correct?
I did not talk about this on direct examination, but I did find fingerprints of Haley Lee on the interior passenger side door of the defendant's vehicle.
Right, and the fact is, Detective, you knew that Adam Smith and Haley Lay had been dating before, correct?
Yes, ma'am, that is what the defendant had claimed.
On top of that, Adam and Haley had been good friends, correct?
Yes, ma'am.
So Detective Stoneridge, isn't it in fact true that you knew Haley Lay was a frequent passenger of Adam Smith's car?
Well, all I can conclude from the fingerprint evidence was that there was the victim's fingerprints on the interior passenger side door. I cannot conclude that the victim rode in the defendant's vehicle, only that her fingerprints were found on that interior passenger side door.
So Detective Stoneridge, it's your testimony today that you're unaware Haley Lay was a frequent passenger of Adam Smith's car?
Throughout my investigation, I did learn about that, but again, from the fingerprint evidence, I cannot conclude that she was a frequent passenger, only that her fingerprints were on the interior passenger side door.
Wait, Detective Stoneridge, I just want to clarify this 1 second. So 1 minute you told us that you didn't know she was a frequent passenger, and then 1 minute you did tell us she was a frequent passenger. So yes or no, did you know that Haley Lay was a frequent passenger of Adam Smith's car?
Ma'am, I never claimed that the victim was not a frequent passenger in the defendant's vehicle.
So then, bringing you back to my question, that was a yes?
Yes, ma'am.
All right, so on top of this, you found Haley Lay's hair fibers in Adam Smith's car, correct?
Yes, ma'am, in the trunk of the defendant's vehicle.
The fact is, Adam Smith told you an explanation of why her hair was in the car, didn't he?
Yes, ma'am.
Right, on top of this, you also found a blue nylon rope in Adam Smith's trunk, right?
That's correct.
So on that blue rope, you never once found Haley Lay's DNA, correct?
No DNA was extracted from the rope.
You also never once found Haley Lay's skin cells on that blue rope, correct?
No, ma'am.
You were also at the burial site at Olentangy Park, weren't you?
That's correct. My job as a detective was also to investigate the scene.
So when investigating the scene, you never once found any blue rope fibers at the burial site, correct?
No, ma'am, not at the burial site. But again, I was not the only detective on this case. Me personally, I did not find blue nylon tow rope hair fibers at the victim's burial site. But again, I was not the only detective on this case.
So redirecting you back to my question, you yourself never found blue rope fibers on that scene, right?
No, ma'am.
Now next, you decided to interview Adam Smith after you conducted all these investigations, right?
Well, I interviewed him before we conducted all these investigations, and I interviewed him for a second time after we obtained information.
Okay, so let's focus on that second time you interviewed Adam. Now, when you interviewed Adam, Detective Strickland went with you, didn't she?
Yes, ma'am, that's correct.
She actually Mirandized Adam Smith, correct?
Yes, ma'am, that's correct.
As an officer, you know that those Miranda rights allow Adam Smith to remain silent during questioning, correct?
Yes, ma'am. He also has the right to an attorney. If he cannot afford one, one will be provided for him.
Well, Detective Stoneridge, in your own words, you told Adam Smith that he had no alternative but to respond to your questions. Isn't that right?
Well, the defendant could have remained silent and used his Miranda rights, but at that time the defendant began speaking, and once you begin speaking, you waive your right to remain silent.
Well, Detective Stoneridge, you say that the defendant could have remained silent, but the fact is, that's not what you told Adam Smith, right?
I was investigating this case, and our job as detectives are to get information from a possible defendant.
So, Detective Stoneridge, bringing you back to the original question, yes or no, did you say the words no alternative option?
Yes, ma'am, I did.
Now, next, Detective, you ultimately decided to arrest Adam Smith only after Morgan Reynolds came forth with testimony. Isn't that right?
Well, we looked, of course, at the totality of the evidence, and the final straw was Morgan Reynolds' testimony.
So let's talk about that final straw then. So back in the original murder trial in October of 1999, you testified to the jury and you told them that Adam Smith and Morgan Reynolds went to Cardinal Park. Isn't that right?
Your Honor, hearsay as to those statements.
Your Honor, may I respond?
Yes.
Your Honor, pursuant to Rule 801D1, this does permit me to cross-examine this witness on inconsistent statements by another witness. Your Honor, I would like to make a proffer that Detective Stoneridge will testify and explain an entire scenario in which Morgan Reynolds and Adam Smith traveled to Cardinal Park. Morgan Reynolds today has recanted that testimony and saying that they never went to Cardinal Park, and therefore this goes to prove the inconsistencies within the statements testified.
Your Honor, may I respond?
Sure.
First, in this jurisdiction, offers of proof or proffers are not allowed. Secondly, opposing counsel objected to this on my direct examination that the statements by Detective Stoneridge presented to the jury in the original trial were inadmissible.
Your Honor, if I may respond?
Sure.
Your Honor, I never did object to Detective Stoneridge in talking about Morgan Reynolds' testimony, again, because pursuant to Rule 801D1, this does permit the cross-examination of inconsistent statements by a witness.
Objections overruled.
Yes, Your Honor.
Thank you, Your Honor. So, Detective Stoneridge, in the original murder trial in October of 1999, you told the jury that Adam Smith and Morgan Reynolds went to Cardinal Park. Isn't that right?
Yes, ma'am.
The fact is, Detective Stoneridge, that's a lie that you told the jury, isn't it?
Well, I told the jury what I knew at that time. Now we know that Morgan Reynolds had lied at the time to us, and they actually went to Olentangy Park. I did not lie on the stand, of course.
Well, you did say those words to the jury that Morgan Reynolds and Adam Smith went to Cardinal Park, correct?
That is what had been told to us at the time.
The fact is, Adam Smith's original defense counsel never once questioned you on those statements of Cardinal Park, correct?
No, ma'am.
On top of this, they never brought out that inconsistent statement, correct?
No, ma'am.
So finally, Detective Stoneridge, you're also aware that Morgan Reynolds claims she was in Adam Smith's white Oldsmobile Alero on the way to Olentangy Park, right?
Yes, ma'am.
She also claims that she was in his car on the ride back, correct?
That's correct.
The fact is, despite what Morgan Reynolds claims, when you searched Adam Smith's car, you never once found Morgan Reynolds' DNA in his car, correct?
No, ma'am, we never did. We only found the fingerprints of the victim and the defendant.
So despite the fact that Morgan Reynolds claims she was in Adam Smith's car, you never once found a single shred of forensic evidence of Morgan Reynolds inside his Adam Smith's car. Isn't that right?
We did not.
Thank you, Your Honor. No further questions.
Redirect?
Yes, Your Honor. Detective Stoneridge, on cross-examination, Ms. Yan asked you about the DNA evidence and other evidence that you did not find. What evidence did you find?
We found a blue nylon tow rope consistent with the murder weapon, along with the victim's hair in the trunk of the defendant's vehicle.
Ms. Yan also stated that the defendant offered an explanation. What was this explanation?
The defendant offered an explanation that this blue nylon tow rope was part of an emergency roadside kit.
In the explanation as to the hair?
The defendant claimed that at a picnic the previous summer, the victim accidentally slipped and fell and hit her head in the open trunk of his car.
Thank you. I have no further questions at this time, Your Honor.
Any recross?
Yes, Your Honor, briefly. May I proceed, Your Honor?
You may.
So Detective Stoneridge, Mr. Dingra came up here and asked you about the explanation as to Haley Lay's hair fibers. Now, in your investigation, you never once conducted an additional investigation to see if that explanation was true or not, correct?
Well, ma'am, all I can conclude from the evidence was that 6 strands of hair were found in the trunk of the defendant's vehicle.
So in regards to Adam Smith's explanation, you never took further action to see if that story was true. Isn't that right?
My job as a detective is only to collect evidence and relay this evidence to the prosecutor. I am not asked to draw conclusions as a detective.
So you're telling us that you collected the evidence and nothing more. Isn't that right?
And I investigated this evidence.
So bringing you back to my original question, that's a yes. You never conducted further investigations as to the hair fibers?
Well, they were a match to the victim, of course. We sent them to the crime lab. I asked the defendant about these hairs, and the defendant gave me that explanation.
Thank you, Your Honor. No further questions.
Thank you. Does the prosecution rest at this time?
Yes, Your Honor. At this time, the prosecution rests.
At this time, I'll allow 2 minutes for each side to prepare your closing arguments.
Yes, Your Honor.
So right now, the students have a couple of minutes to prepare their closing arguments in the fictional court case, State of Buckeye versus Adam Smith. After the teams deliver their closing arguments, the judges will adjourn for a short while to deliberate, during which time I'll have a chance to talk with some of the students participating today and get some of their perspectives. When the judges are back from deliberating, they're going to come back, give comments, and then announce the winning team. But first, we'll go back to the floor to hear the closing arguments.
both sides ready then to make your final arguments?
Yes, Your Honor. The defense is ready.
Yes, Your Honor.
Okay.
The prosecution is ready to proceed.
Ms. Yan, then you may proceed.
Yes, Your Honor. May I proceed?
Yes.
May it please the court. Justice isn't only for one side, but it must be served for both. And while justice must be served for the individual responsible for Haley Lay's murder, justice cannot be achieved when the accused is denied the most fundamental right protected under the Sixth Amendment to the Constitution, the right to a fair and reliable trial. As recognized in both the Bigelow's and Matthews court decisions, an individual's Sixth Amendment right is violated when the defense counsel fails to present an alibi witness. And Your Honors, as you have heard today, this is exactly what happened. Adam Smith's defense counsel failed to investigate alibi testimony. They failed to call alibi witness. And they failed to develop cross-examination that would have supported alibi claims. Now, the Supreme Court of the United States, in its Strickland v. Washington decision, established a two-pronged test that must be met when determining whether or not an individual's Sixth Amendment right was violated. First, that the defendant's counsel committed unprofessional errors during trial and their performance was deficient. Second, as it is related to prejudice, the defendant's counsel committed unprofessional errors that were prejudicial to Adam Smith's defense. Today, it is the burden of the defense and not the state to prove reasonable probability that the results would have been different, but for counsel's unprofessional errors. Now, the key issue of today's case is the failure of Adam Smith's defense counsel to develop an alibi defense. The importance of alibi witnesses cannot be understated, especially when, over 18 years ago, after Haley Lay was murdered, the prosecution was left piecing together a case based upon circumstantial evidence. The state's one eyewitness to the burial of Haley Lay's body was Morgan Reynolds, who had an incentive to lie. And the blue nylon rope lacked Haley Lay's DNA, forensic evidence, and skin cells. Your Honors, when this was all the prosecution was left with, it was incumbent upon Adam Smith's defense counsel to investigate alibi witnesses. But as you have heard today, Adam Smith's defense counsel never did this. As recognized by the Sixth Circuit Court in the Bigelow decision, an individual's Sixth Amendment right is violated when the defense counsel knew of promising, credible, disinterested alibi witnesses, yet they failed to investigate those alibi witnesses. Today, Adam Smith's original defense counsel was well aware of an alibi witness for Adam Smith, Randy Johnson. In fact, Randy Johnson told us that she called and left numerous voice messages to Adam Smith's defense counsel, trying to tell them that she was an alibi for Adam Smith. But Adam Smith's original defense counsel chose to ignore her calls and her voice messages. They had received reasonable notice of an alibi witness, but they chose to do nothing. In addition, had Adam Smith's original defense counsel conducted a reasonable investigation, as required in the Bigelow's decision, they would have discovered the after-school homework help sign-in sheet with Adam Smith's signature on it, and they would have identified a host of additional alibi witnesses in the form of students who also attended the homework help session. Now today, you have also heard from Addison Waranowitz, a cell phone data analyst and expert. She told us that in the first murder trial of Adam Smith, she testified on behalf of the prosecution. She told us that Adam Smith's original defense counsel failed to conduct a proper cross-examination that would have supported alibi claims. She told us that Adam's original defense counsel failed to point out that Adam's cell phone records are completely consistent with Randy Johnson's alibi claims, and that they actually corroborate her alibi statements. Your Honors, in the end, justice must be served for Haley Lay's murder. But for justice to be effective, the defendant deserves a fair and reliable trial, something he was denied for 18 years. For this reason, we ask the court to uphold the defendant's claims to violation of the Sixth Amendment rights and to grant Adam Smith a new trial. Thank you.
Mr. Dingrer, you may make your closing argument.
Yes, Your Honor. Your Honor, opposing counsel, may it please the court. The jury already heard what they needed to hear. In October of 1999, the defendant was tried for the murder of Haley Lee. He was tried by a jury of his peers, and that jury found him guilty, beyond a reasonable doubt. Today, the defendant is asking you to set aside that verdict and order a new trial based on an alleged violation of his Sixth Amendment rights. The Sixth Amendment to the United States Constitution guarantees the right to a fair trial, including the right to be represented by an attorney. Our founding fathers recognized the importance of the adversarial process to ensure that innocent citizens weren't convicted of crimes they didn't commit. As the United States Supreme Court explained in Strickland v. Washington, every person accused of a crime has the right to be represented by an attorney who meets at least the minimal standard of reasonableness. Now, we admit that the defendant's representation fell below the reasonable standard of care. We concede that his attorney was ineffective, but in order to prevail in their motion today, the defense had to show you that counsel's errors actually prejudiced the defendant. As the United States Supreme Court explained in Harrington v. Richter, they had to show that counsel's errors were so egregious, the defendant was deprived his right to a fair trial. And they have failed to meet their burden. They have failed to meet their burden because the evidence presented against the defendant in the original trial was so overwhelming, counsel's errors didn't matter. All of this new testimony is nothing but an attempt to distract the court from the evidence. First, the victim's hair was found in the defendant's trunk. In his trunk, Your Honor. This is the same place where Morgan Reynolds told us the defendant showed her the victim's body. And second, the murder weapon was found in the defendant's trunk. You heard Detective Stoneridge tell you that when the defendant offered an explanation as to why a blue nylon tow rope was found in his trunk, he said it was part of an emergency roadside kit. But none of the other items were found, just the rope. That, Your Honor, is what the jury needed to hear. In opening statements, Ms. Roku stated that the best defense is an alibi. But let's look at that alibi. The defense tried to distract you with the testimony of Randy Johnson, the defendant's so-called alibi witness. But Ms. Johnson admitted that she was friends with the defendant's aunt and couldn't give us any other people that could corroborate her testimony. She didn't think to track down this alleged sign-in sheet until 19 years later, and most importantly, the defendant never even claimed to be at homework help that day. The defense also called Ms. Addison Waranowitz, stating that the jury was misled by expert testimony in the original trial. But Ms. Waranowitz admitted on cross-examination that she never testified as to the defendant's exact location, only that the data she reviewed corroborated the prosecution's eyewitness account. Counsel's failure to challenge this opinion wouldn't have affected what the jury heard. Ms. Yan argued in closing arguments that justice isn't for one side, but Your Honor, in this matter, justice has been served. Justice has been served to Adam Smith for his brutal murder of Haley Lee, and justice has been served to Haley Lee's family. Your Honor, all this is smoke and mirrors, intended to distract the court from the evidence. Just because there are things the jury didn't hear doesn't mean the defendant is entitled to a new trial. They have failed to meet their burden that he was prejudiced, and they have failed to meet their burden that he was deprived his right to a fair trial. For these reasons, we respectfully request that you deny the defendant's motion for a new trial, because the jury already heard what they needed to hear. Thank you.
Thank you. Does the defense wish to make any rebuttal argument?
Yes, Your Honor. May I proceed, Your Honor?
You may.
Today, Mr. Dingra comes up here and tells us that the jury already heard what they needed to hear. But Your Honors, that simply isn't the case. In the original murder trial, the jury never heard Randy Johnson. The jury never heard alibi claims. The jury never heard the full extent of the cell phone data technology, and to realize that that technology and that information corroborates with the alibi claims. Now, on top of this, Mr. Dingra wants to come up here and talk to us about overwhelming evidence. But again, this isn't the case. Let's look to the state's chief witness, Morgan Reynolds. Today, Morgan Reynolds only told us a story of half-truths and half-lies. Morgan Reynolds testified and said around 3:47, Adam Smith was at her house. But today, we have proven that the cell phone data technology absolutely contradicts that statement. In addition, Morgan Reynolds claims that she was a co-conspirator of Adam Smith. But Detective Stoneridge admits during cross-examination that there was not a shred of forensic evidence of Morgan Reynolds that could corroborate that statement. Your Honor, opposing counsel wants to tell us that we as the defense are only distracting this court with Randy Johnson's alibi claims. But it is clear that they are only distracting us with Morgan Reynolds' story of half-truths and half-lies. But in addition, if we look to what Randy Johnson has to say, she was a credible, disinterested alibi with no reason to lie like Morgan Reynolds did today. But Adam Smith's defense counsel failed to once answer her phone calls or messages, effectively silencing her and denying Adam Smith justice for 18 years by failing to call an alibi witness, by committing an unprofessional error that rose to the level of prejudice. Your Honors, tonight, when you go back and deliberate, remember that you have the chance to do something his original counsel didn't, and that's to bring justice back. Thank you.
Thank you. At this time, the scoring judges will retire to begin deliberations on their
Once again, you're watching the Ohio Channel and the 2018 Ohio High School Mock Trial State Championship. We're coming to you live from the Ohio State House in downtown Columbus. The sponsoring organization for the Ohio Mock Trial Competition is the Ohio Center for Law-Related Education, or OCLRE, which has been educating students about their constitutional rights and responsibilities through this program since 1983. The Supreme Court of Ohio, along with the Ohio State Bar Association and the Ohio Attorney General and the ACLU of Ohio, are OCLRE sponsors. After growing steadily over the past 35 years, OCLRE's Ohio Mock Trial Program is the largest non-athletic competition in the state, with about 3,000 students participating and more than 1,000 legal professionals volunteering as legal advisors, case committee members, and judges. Mock trial offers high school students an opportunity to participate in some of the serious legal scenarios that lawyers and judges deal with every day in courthouses across the state. Since 2014, the Ohio Channel has produced Ohio County Courthouses, Seats of Justice, a documentary series exploring the history, architecture, and unique purpose of each county courthouse in Ohio. Let's take a look.
Whether you live in one of Ohio's bustling cities or one of its quaint county seats, one building seems to attract attention.
My name is Jessica Daniels. I live in Dover, Ohio, and I'm a high school Spanish teacher.
Patrick Shepard. I was born and raised in Wellington, Ohio, in Lorain County, and I currently live in Cleveland.
My name is Hannah Tucker. I am from Tiffin, and I am the pastor of St. Paul's United Methodist Church here in Tiffin.
What do a teacher, amateur photographer, and a pastor have in common? A love of history, travel, and Ohio's county courthouses.
This summer, my sister and I went on a trip and we visited all 88 counties and their courthouses. Something we've wanted to do since we were kids, so we drove around the state of Ohio in 7 days.
We kind of divided it into quadrants and basically just printed off a map of Ohio and kind of took a pencil and sketched in a map that we think would work. The first day we started out, we visited 15 or 16 counties in the first day, and we were exhausted, worn out. You know, it was too much. And so then after that, the remaining 6 days, we ended up usually between 9 and 13 counties a day we were able to get to. And it was usually a full day, 10 to 12 hour day in the car.
I used to travel across Ohio quite a bit, and I often noticed that the most beautiful building in the whole county was typically the county courthouse. And I always wanted to go back and visit some of them. And it wasn't until about 2012 when I saw an article in the Toledo Blade about endangered courthouses in the state of Ohio. And then it occurred to me that my home courthouse in Lorain County had really fallen into disrepair. I think the purpose overall was to not only revisit a lot of these county seats and see these courthouses, but also to bring some attention to the fact that there are some endangered courthouses. I really feel that these buildings are of such significant historical and architectural importance that for me as an amateur photographer, I just thought it would be an interesting project to try to grab images of all 88.
We don't build courthouses like we did in the 19th century and early 20th century. This is a time period when there's a lot of attention given to the architectural details that go into the buildings. These were intended to be buildings that stood out, were monumental, in many cases probably the most architecturally distinct building in the counties, in the respective counties, especially in often the more rural counties.
Mostly after we saw all the courthouses, I was amazed at just how different many of them were. They were built at different times. When you go into the bigger cities, they look more like just normal city buildings. And in some of the smaller towns, they're clearly the most majestic, the biggest building in the town.
My favorite courthouse was located in the town of Pomeroy, which is Meigs County, down on the Ohio River. It's a tiny little town, and the way the geography is down there, you have the river and then pretty much you have hills directly after that. So the courthouse was actually built into the hill. There were levels of the courthouse, and each level had a ground entrance because you could work your way up the hill and enter in different places. So it just had some really unique features to it.
My favorite courthouses were those where it really was the focal point of the city or town, that there'd be a good amount of green space around it, and then a commercial district. You know, there might be an old theater there, barber shop.
My favorite courthouse was in Hardin County, in the town of Kenton. I really liked it because Kenton's a pretty small town, and you drive into the downtown and then you see this courthouse, and it's kind of up on a little hill in the center of town, and you can see it from far away, and it's just this beautiful big building in the midst of this tiny town.
Ohio Ohio's historic courthouses, to me, really reflect the breadth and diversity of Ohio's history. These were meant to be symbols of county government, symbols of our rule of law, places where people came to make very important decisions that shaped their lives.
Now that I've been to every courthouse, I realize that they belong to us as Ohioans. They belong to us as members of each county. It's worth checking out your local courthouse, I think, because of the history, the architecture. You might learn things about your county or your community that you didn't know from before. I got to spend 7 days in a car with my sister. We got to learn a little bit more about each other. I know a lot of people don't get to have close relationships with their siblings, and I'm happy that I do have one and that we got to spend this time together because it's not a common thing.
Ohio reflects this checkerboard pattern of roads and farms and fields that were all very orderly, put together in a very rational rectilinear plan.
Some of my favorite days each year is when I'm just kind of meandering across Ohio and picking up these photographs of courthouses. And what I love about it is it's one of those things that it's not specifically the destination, it's the journey. So it's going on all these old Ohio roads and then, learning and discovering about the history of these various cities and towns along the way.
You can find the entire Ohio County Courthouses Seats of Justice series at ohiochannel.org/courthouses. As the judges are deliberating and scoring, let's hear from some of the students who are participating in the mock trial today. So you can come forward here. What's your name?
My name is Jake Kearns. I'm from Springfield High School.
And what grade are you?
I'm a junior this year.
So how do you feel about how the competition went?
I think it went really well. I think our attorneys performed perfectly. I thought Emily, Morgan Reynolds, did awesome in the trial. I'm just really proud of the team right now.
What went into preparing to be a witness today?
A lot of preparation on possible cross questions and many practicing on direct examinations with my attorney.
So how long have you been playing this character?
All year this year.
And you reached the state championship level. Was there anything that you heard today that caught you off guard that you'd never heard before?
I've pretty much practiced everything. I mean, some of the questions are worded differently, so it's kind of confusing at times. But I think our team prepared well. I think we were prepared for any competition in this tournament.
And what got you into getting into mock trial?
My sisters actually were on this team 2 years prior, and so they brought me into it with open arms, the team, the coaches. So it's just kind of in the family. I've always been doing it.
So I feel like there's always two elements to being in mock trial. There's the dramatic side of things, and then there's the legal knowledge side of things. Which attracts you more?
I'm more on the lay witness side of things. I'm more of a character. I can just, over the summer we did Empire. I was a ghetto witness. And this year I was a cop, so I just have fun being a character witness. I'm not really smart with the legal stuff, so.
But do you like doing drama stuff? Do you like acting?
No, I'm not in any drama plays, but I do like acting. It is fun.
All right, great. Thanks a lot. All right, come on up. What's your name?
I'm Indingra. I'm from Springfield High School.
And what's your grade?
I'm a senior.
So how do you feel about how things went today?
I think it was a really close trial. Sylvania is obviously really, really good. That's why they're here. I think we had a good trial overall. Everything went kind of as we planned, and it'll be close. I'm not really sure.
So again, I'll ask everybody, was there anything that happened today that kind of caught you off guard, something you'd never seen before?
Some of the objections that I got were unbelievable, and you kind of just have to think on your feet. That's normally how it is, so you don't know what you're going to get. But we've heard Almost everything at this point, because just so many competitions leading up.
Well, so that one time you had a good exchange back and forth between some of the objections, but you had a court case that you were ready to cite on the spot. So did you practice for that?
Yeah, we kind of prepared for that because it's like determining whether there should be a new trial. There's a court case that specifically talks about that. So our coach prepared us for that basically perfectly.
What got you into doing mock trial?
I have no idea. I don't even know how I'm still here, but I am, so.
Do you think that you'd ever want to be a lawyer someday? Do you like the legal stuff?
I think I'm going to go to dental school, so probably not, but you never know. We'll see.
You could look into dental law.
Yeah, we'll find out. I'm not sure, but we'll see.
All right, great. Thanks a lot. Come on up. What's your name?
Emily Haseki, and I'm from Springfield High School as well.
And what grade are you?
I'm a junior this year.
So what got you into doing this?
I love acting, and I do theater at school, so I thought mock trial would be fun, and I've had friends do it in the past.
And so was there anything that kind of caught you off guard? What was the highlight of today's competition?
Well, I really enjoyed my cross. I've heard those points made before, but every time's just a little different with the way they word things, so trying to figure out how to respond in a way that best suits your character and best helps your side.
You said you like acting, and you really kind of sunk into the drama side at times, so do you do theater at school?
I do, yeah. We're doing Legally Blonde this year, so I'm in that
perfect.
musical, yes.
So they made sure to really do a
yeah, a little different than this try, yeah.
All right, great. Is there what are you going to do when you grow up? Do you think you want to go into acting?
Probably not. Probably along the teaching side, yeah.
Any message you have for your team and your advisors?
I'm so proud of everyone on this team. Springfield hasn't made it this far yet, and so it's an honor to be on the first team that's made it to the final round.
Great. Thanks a lot.
Thanks.
We're going to keep it rolling here. Hi. What's your name?
I'm Caroline Osborne.
And you go to Springfield, and what grade are you?
I'm a senior at Springfield High School.
How long have you been doing mock trial?
All 4 years.
Okay, what got you into it?
My mom's actually the coach of our mock trial team, so it was kind of a requirement.
Yeah. So did you grow up watching mock trial? Did you grow up watching these competitions?
Yeah, my mom started coaching when I was in the 6th grade, so I've been going to competitions for 8 years.
What's it like to see that growing up and now to be at the state championships your senior year?
It definitely provides a layer of insight, and everything that happens in the trial, I can remember, when I was in the 7th grade, I saw this happen in a trial. So it really is good to have that background knowledge.
Yeah. So you've seen these big competitions before, and you're kind of more used to it because you've seen it before.
Definitely. I've always known what to expect from my freshman year of how the trial is going to go and how the judge might rule on certain things.
That's cool. Was there anything that kind of caught you off guard today? Anything new that you haven't seen?
Of course, every trial, opponents' themes are different, and their theme was absolutely phenomenal, and we had to think on our feet of how we were going to twist that and respond to that.
Now, you found out what side you were going to be arguing last night, is that right?
Yes.
And so what's that like to not even know who's going to be arguing what side until the day before?
It's definitely stressful, but it was nice to know at least the night before so we could focus, because I'm going to turn on the other side so I could focus on this speech and these crosses. So it was nice to find out the day before.
Okay, great. Anything else to add?
No, I'm just proud of our team and how we performed today, and also congratulations to Sylvania. They were fantastic.
All right, thanks a lot. All right, come on up. Hi, what's your name?
Shruti Dixit. I'm from Sylvania, Southview High School.
And what grade are you?
I'm a senior.
So what got you into mock trial?
Well, I know someone said it before, but it's basically been in the family. My sister did it for all 4 years, and I followed in her footsteps and did it all 4 years as well.
So you grew up watching your sister do this?
Absolutely. I remember going to a lot of her competitions, and I just saw the way that she carried herself and how it required so much teamwork, and it really resonated with me to maybe try this program and see what I could probably get from it, and I did get a lot.
What was she ever in the state championship?
Not,
or did you ever get to see
well,
a state championship?
I believe they did have a chance at states, but they didn't make it as far. And I'm really fortunate that my team and I were able to make it this far, and it's been an honor.
What's a highlight from the case that you just played out here?
Well, I mean, something that was interesting was some of the cross points that were brought up. It's something, you know, after all these trials, you've heard basically the entire gist of it, but here, my opposing counselor, who was crossing me, she did actually bring up some points that I wasn't necessarily familiar with, so it was definitely different.
Kind of proof that these are the top two teams in the state to come up with something that you haven't heard before.
Right, exactly. And I mean, Springfield was great. Their competition was absolutely amazing, and it just showed that we were both able to defend our own sides, and we were able to do so in such a friendly way. Yeah.
So, we talk about the legal side of things and the drama side of things. Which one do you sway on? Do you like the acting side, or do you like learning about law?
I like both. I've been a witness and an attorney, but this year I kind of dialed it down and decided to have a better chance at being a better witness, and I was able to do that.
Great, thanks a lot.
Thank you.
Hello. Hi. What's your name?
My name is Larky Ann. I'm from Sylvania, Southview.
And what grade are you?
I'm a senior.
So what role did you play today?
I was an attorney on the defense side.
And you were the one bringing out those objections and the cross, and so what was it like to really have to stand your ground and constantly fight for those objections?
I think it was a really, kind of fun opportunity. Throughout the trial and throughout competition, we've obviously had to raise a lot of objections. Springfield's put up a really good fight, so it was fun just being able to battle that out with them.
So you've done that before, raising those objections and fighting that case?
I have. Yes, I have.
So what's it like to never really know where the judge is going to fall on that, or does the judge usually favor your side?
Not always. I've seen all different rulings from judges, so definitely when raising those objections, it really keeps you on your toes. You need to make sure you are ready for whatever the judge rules, and it definitely is. It can be nerve-wracking, but it's also a great experience in learning how to speak on your feet and stuff like that.
What got you into doing mock trial?
So, like the previous person, also my sibling was a part of the program, and she always told me about how much she loved it and how it was an awesome experience for her. So I wanted to try it in high school, and I've been here ever since.
Great. Anything else to add? Anything you want to say?
I guess I'm just really proud of our team for making it this far. Springfield's was amazing, and it was really great just being able to carry out a trial with them. It was a fun time. It was a really good experience. So just overall really proud of our team in general.
Great. Thanks a lot. Thank you. All right, who's next? Hello.
Hello.
What's your name?
My name is Elizabeth Roca, and I go to Sylvania Southview.
And what grade are you?
I'm a senior this year.
What got you into doing mock trial?
Well, I didn't have a sibling who was in mock trial. I always kind of felt like I wanted to become a lawyer eventually, and my school has a very reputable program, and it's coached by amazing people. So I thought I joined 3 years ago, and I haven't looked back since.
So you did join it kind of more interested on the legal side of things?
Absolutely. That's why I'm here, and that's why I've been an attorney for all 3 years.
And so where does that take you after you leave Sylvania? Do you think you want to go into law school someday?
At this point, yes, but future still to be determined.
But this didn't do anything to sway you away from law. This piqued your interest in law?
It absolutely did. This year I doubled on both sides in the case. I was happy this was the easier side for me because I only open. On the other side, I get the closing, and I have to be the one more on my feet and on my toes. But it's an amazing round. Springfield did great, and just can't wait to see what happens.
And so what was maybe a highlight of the trial today?
Oh, the objections on both sides. That back and forth exchange is probably the most fun part of the trials, and the arguments were so eloquent and were so well put together. I think that was definitely the highlight on both sides.
Any message that you have for your team and your advisors?
Love you guys. Hope we can go on. Good job.
All right, thanks a lot. Come on up. What's your name?
Hi, my name is Kaylin Lee. I'm from Sylvania Southview.
And what grade are you?
I'm also a senior.
And remind me, what role did you play today?
I played the teacher in today's case.
The one that was looking out for Adam Smith. And so what was a highlight of the case today? You had two of the best teams in the state going back and forth.
It was a really tight round. Honestly, the competition and just being here feels so surreal. After all of our hard work, it's been amazing. Yeah.
What got you into doing mock trial?
I actually had an upperclassman friend who introduced me when I was, it was before my sophomore year that I got into mock trial.
And you thought it'd be fun to join in?
Yeah, I did, and it's been a great decision.
So you were a witness. Does that mean that you like more of the drama side of things, or do you also appreciate the legal side?
I appreciate both, but I definitely lean towards the dramatic side. I've always played a witness, and so that's what I'm more familiar with.
What is there? Is that are any of the elements that you did here today? Is that going to play into what you want to do when you leave high school?
No, not really. Actually, it was just really great, and my team we're all really close, and it's just been a great opportunity for us.
Do you have a message for your team and advisors?
Yeah. I love you guys. Knock on wood. I hope we move on, and I love you guys so much. But yeah, that's it.
Thanks. That must have meant something. All right, come on up. Hi. What's your name?
Felix Griffin.
And you are from Sylvania, and what grade are you?
I am a senior.
And you played the role of the timekeeper today?
Yes, I did. I misspoke and I said portrayed. At least it got a good laugh out of the judges,
Right.
so that was good.
Yeah. And so today you were timekeeper. Were you? If the other side had argued today, would you have been a different character?
Yes, actually, I would have been the detective Stoneridge if we were on the other side of the case. But
So you got the chance to see somebody else play this role many times, I'm guessing. So what do you think about how this detective did, and what kind of angle did he take compared to the angle that you would have taken?
The way I recall, it was very similar. He was very effective in his speaking, and I think he really took the character really well. He was the stone cold sort of stand up straight, no nonsense sort of guy.
Now, everybody says that the highlight for them was the cross-examination and the objections going back and forth. The detective ends up being the person who is sort of in the middle of all that drama. So have you played the detective when you do see the two counsels going back and forth?
Yes. When Judge McBride started going a certain way on those objections, I kind of had a thought in my mind, it's going to be very difficult for this detective to get out of these things, because I've been there too, and I've had those hearsay objections sustained.
Yeah, because you're thinking, oh, well, if that were me, how would I try to change my answer so nobody gets to object to anything?
Right, exactly.
So what got you into mock trial?
Well, going into freshman year, I sort of just heard of the Lyle mock trial legacy, so I decided to go to the first meeting and join up, and I've been here ever since.
Does this play into anything you want to do once you leave high school and maybe go on to college?
Yeah, it gave me a possible career path. I'm considering law very strongly in the future for me.
All right, great. Thanks a lot.
Thank you.
Hello, come on up. Hi.
Hi.
What's your name?
My name is Katie Osborne.
Okay, and I think your daughter I just talked to your daughter, is
Yes,
that right?
my daughter was the opening attorney in this round.
Okay, so you're with Springfield?
I am.
Okay. How long have you been there?
I have been coaching since the program began, and this is our 7th year.
Okay, great. Well, first of all, congratulations on being your first time in the state championship, so that must be a great feeling.
Yes, we were floored and very excited and honored to be here.
What goes into being an advisor for a mock trial team?
Oh, gosh, a lot, everything. There's obviously we teach them what we can about the substance of the law. We teach them their performance skills, but we also teach them about good sportsmanship and how to interact with their opponents, with their advisors, with each other and their other teammates.
I think good sportsmanship is a really interesting and important key, because there are times when you're literally arguing with the other team and it can get really combative at times. So is it difficult to teach teenagers how to do that in a respectful way?
Yes and no. I mean, I think they get it. The kinds of kids who are attracted to this program are usually kids who really want to present themselves well and want to work hard to show their best side. And we teach them to be respectful of everyone and to fear no one.
It's like the whole disagree without being disagreeable.
Absolutely. Present your argument in a respectful manner and be articulate and accept the consequences, whichever way. One of the best skills they learn in mock trial is how to react when an objection does not go their way, and not to show on their face their disappointment, and just to move on.
I thought, and that your team had to do that a couple of times, and I thought they did a good job with that.
Thank you very much.
So when did you find out that this was the case that you're going to be arguing?
We've been preparing for this case since last fall, October.
And then you argue it over and over again, is that right?
That's right. We do some invitational tournaments and some scrimmages, but the first official OCLRE competition was districts in January.
So you've seen it a lot. Is there anything that you saw here this morning that was new, that's kind of caught you off guard?
I don't think the kids were caught off guard, because I think they were ready for it, but this was the first time that they have gotten objections against them sustained on the detective. So there were a lot of evidentiary issues that did not get to come into today's trial. I thought they did a great job recovering from it, though.
All right, great. Any message that you have for your team?
Well, I thought they did great. I was really proud, but it was a great round, and I couldn't have asked for a better opponent either. Actually, Sylvania's coach has been my mentor, and he actually has been working with me over the years to help me build up my program. So this was kind of ironic that our first time here we got to face them. So I was really proud.
That's really cool. All right, thank you very much.
Thank you.
Hi. Hi. I'm Andy. So what's your name?
Denny Lyle. I'm the Sylvania Southview legal advisor.
Okay, and so as the other advisor just said, that you've been her mentor for.
Yeah, about 5 years ago, she calls me up and says they'd like to follow in our footprints. And so I helped coordinate her working to some of these international competitions. And ever since then, we text our texts are probably hundreds and 200 long at any given week and sometimes there. So we go back.
How does it feel to find out last night that you two were the two teams going up against each other?
Actually, we're delighted because coming into it, although I have a lot of friends out there, if we don't win it, I wanted her to win it. So, yeah. So I, we're cheering for them. We were looking for them, but we were tracking the charts to see who, if we're going to draw them sooner or later, though. So we were thrilled with it, though.
Was there anything that you were like, oh, I should have held that back. I shouldn't have not taught her that.
Well, the objections that she was just talking about this morning, because we helped her with those to develop some of it. We actually went back and tried to revise ours, anticipating their objections. Wow. And so the objection battle you saw with the detectives, we had a few little twists that we had not yet used before in the past. So.
Wow. Yeah. So how long have you been doing this?
I've been coaching mock trial 33 years, 9 in college, and the last 24 at Southview. There.
Okay, so and this is the team. So you've been here 8 times then?
This is the 8th time here there. So yeah, it wears me out. I mean, for me, I only saw part of the trial. My stomach was tearing me up in knots. So I'd come in, I'd listen for a second, I'd run out and then everyone would text me as to what was happening in the course of the round. So it was kind of a tough thing for me there.
So doing this for so long, when you work with kids, what kind of value do you see this take place as far as helping kids develop?
I think the maturity level that you learn, it's not just the analysis that comes into play, but dealing with opposing teams and coaches and judges and adults from all parts of the whole state. You kind of learn how to communicate and to develop those communication skills. The analytical and the legal is certainly a part of it, but ultimately it's how you deal with the people and how you can deal with them professionally. That will carry on for the entire balance of their life there.
Any message you have for your team?
Well, I would probably say the power of 6'11". And for us, what that basically meant for us is I lived on 6'11". My mother died on 6'11". We parked our cars at 6'11", our rounds were at 6'11". So for them, the message to them is to stay strong, stay with their family, and that whatever the outcome may be, we'll have a great representative from the state of Ohio.
That's great. Thank you very much.
Thank you very much.
All right. So is there anybody else any other advisors? Hi. What's your name?
My name is Mike Osborne.
Okay, and what team are you with?
I am one of the legal advisors with my wife for the Springfield team.
Okay, and how long have you been doing that?
I've been with the team for the past 3 or 4 years. I did not coach in the beginning, but since my family was so dedicated to mock trial, my wife, my daughter, my son before that, I was brought in sort of kicking and screaming, and now it's one of my passions as well.
So what do you do as an advisor?
We spend a lot of time, we do our practices at our house, so we are spending a lot of time working with those kids, teaching them about the law, teaching them how to present and make arguments, and how to really be good citizens and good people in the courtroom.
So is this something you do for a living? Are you yourself an attorney, or is this something you, okay.
Yes, I am an attorney.
So you bring real life experience to it too.
Not really, because I'm a tax attorney and a business attorney, so these kids are doing stuff in the courtroom, making objections on hearsay, and I really had to go back and learn the rules of evidence, because it had been 20 years since I looked at them in law school, so the kids and my wife have taught me a lot about how to be a courtroom attorney, something I never do in real life, but it's been fun to learn on my end as well.
What's it like to work with kids and helping them develop through a program like mock trial?
The story I always tell is I watch these kids come in as freshmen, and they are smart kids, they're willing to learn, but the growth you see from the time they go to their first trial as freshmen till a day like this when they're presenting to 5 justices at a final round of a state competition, it is just so amazing to watch how articulate they become, how their public speaking improves. It is just an amazing experience to see what these kids can do.
Any message that you have for your team?
That they should always have fun. One of the advice we got from one of our judges last night is you need to just go and have fun. And if you go and have fun, you're a winner. And win, lose, or draw, our team put everything on the table. I think they had fun, and I'm proud of them.
All right, great, thanks a lot. Do we have any other? Hi, what's your name?
My name's Austin Tyree.
And what school are you?
I'm from Springfield High School.
And what grade are you?
I'm a junior.
So you played a timekeeper here today.
Yes, sir.
Had the coin flipped the other way, would you have played a different role?
I also would have played the timekeeper if the defense was called. And I enjoyed being timekeeper, obviously.
So you've seen all these court cases play out as your team goes up against one team after another. Was there a highlight from today, something that you hadn't seen before?
I really enjoyed Umman's responses to the hearsay objections. As you know, there was some dialogue about the objection between Denny and our coach, so we prepared for them. And last night they stayed up really late, hindering me from getting some sleep working on that. So I really enjoyed being a part of the team, even though I was not performing. I felt as if I was a crucial part to a larger group, so I enjoyed it.
What kind of work goes into being on mock trial? I'm guessing that you have practices after school. I mean, you've been doing this for a couple of months now.
Well, actually, my freshman and sophomore year, I was an attorney. This year, I decided to take a break because of the amount of practice that you have to go through to be a successful team. And obviously, Springfield had to do a lot of work to get to the place that they are today. So it's a lot of work. It's not something you can just do once a week and think you're going to be successful. It takes a lot of work. Practice is almost every day, 2 hours, 3 hours, so it's a lot of work.
And so does this play into what you want to do after high school? Are you thinking about going into law or going into drama?
In fact, I plan on going into law. I eventually want to go into politics, so the setting is perfect for what I'm thinking about my future.
So you scoping out the building here, looking at the offices, taking measurements, yeah?
Yes.
All right. Any message for your team?
Keep up the good work in whatever they do. Some of them are going to college and some of them are pursuing law careers. So they can do well. Just keep up the good work and working hard.
All right, thanks a lot.
Thank you.
Okay, and I think we have, hello. What's your name?
Vicki Lyle.
And you are with?
I assist Denny with the coaching of Sylvania Southview.
Okay, and how long have you been doing that?
Well, Denny's been coaching Southview since '94. I started really being able to provide more substantive help probably in the last decade or so after our kids got into high school.
So what kind of work goes into being an advisor? What kind of things do you do to help the kids?
Well, I would say Denny's the legal mind behind it, but they also need a lot of assistance with being high school students, just getting to and from, kind of reminding them the moment and the importance of it, to just appreciate that. In addition to all the work that they do, to just experience it in the moment and to enjoy and appreciate all the hard work that brought them to this place.
Do you have any message for your team?
I certainly do. So very proud of all of them. Proud of the Springfield team and the Southview team. Takes a lot of work. 400 teams in the state of Ohio, and these two are the finals. So I wish them both well.
All right, great. Thanks a lot. Thank you. All right, so it sounds like the judges might be entering the courtroom soon. So let's go back to the main floor to hear what they have to say.
We're going to start with the debriefing part, and just to change things up, I'll start down at this end this time, and you can go ahead with your comments.
Thank you, Your Honor. I'll preface my comments with, I'm going to defer to those to my left, especially DeGennaro, who's just a recently appointed Supreme Court judge here in Ohio, and our presiding judge, who is a veteran trial court judge, common pleas court judge out of Claremont County. So they would be in a far better position to judge than I. I'm usually sitting in your seats as an advocate as opposed to a judge. But taking it from that perspective, I first want to start with commending both teams. You have exhibited an outstanding level of skill and mastery, discipline, poise under the circumstances. This is like the Super Bowl of mock trial. I was nervous for you, very nervous for you, more nervous than when I go to trial in my own cases. So I can't speak highly enough about both of you. I know what time, energy it takes to make this happen. So on that alone, I think you both deserve a round of applause from everybody here. Very evenly matched. It's clear to see why you have risen to the top of however many hundreds of teams that have competed throughout the state. Without getting into specifics, and certainly reserving time for the rest of the panel, everybody exhibited strengths in various aspects of how they handled the case. I was incredibly impressed with both openings. I thought they were both solid. You laid out the case very nicely. Cross-examinations were good. It is often said cases aren't won on cross, but I thought in this case the cross-examinations were very solid in how you pinned down inconsistencies and issues that had not come up in the prior trial. From all aspects, the direct and then the closes were both very solid. Very impressive. With that, I can't commend you enough. I can only say that I wish that this program had been in place 30-some years ago when I was in high school. I may have found my way to the practice of law sooner than I did. So I wish you all the best, and I wish you all the best in your future careers, as I imagine many of you are heading off to college. So good luck.
Thank you. So I'm going to make one comment with respect to the trial and then just a comment to everyone aspirationally. This is the nicest round I have seen where all counsel consistently, very effectively and appropriately used redirect and recross. You either asked no question or one question, maybe a couple, and it was the exact right question. That is a nuance in trial practice that seasoned lawyers, as my fellow judges will verify, is a very nuanced skill that you all use very effectively. I also like to comment, I want to commend all the students, and I'm talking not only to the 8, math, that made it to the finals. So this is to all the students who have participated in this program across the entire state. You are to be commended. You guys have a lot on your plate. School, work, other student activities, your responsibilities at home. And when you see students who are so willing to invest that extra effort in their education, and specifically trying to educate themselves to be informed citizens, you are absolutely to be commended, as is your teachers, your coaches, your parents and guardians, and the school districts for making this opportunity available to you. I also want to give a shout out to the Ohio Center for Law-Related Education. This is just one of many educational opportunities that center produces, and I think the skills that you learned in participating in this program will serve you well as you go on in life, whether you choose a path in the legal career or elsewhere. So I'm very proud of all of you here today, all of you that participated this year, and I encourage those who can come back, And those who are thinking about this, absolutely get involved in this very valuable opportunity.
Now we'll go down to this end.
Reserving the last word, huh?
Reserving the last word, right.
Well, what I didn't say during my introduction is I'm an alumna of this program. I competed about 15 years ago. My team never made it to the state championship, so I want to commend all of you on that. But I absolutely appreciate how hard you all worked to be here, and I would not have wanted to go up against either of you because I know you would have knocked my team out. So. One thing that I thought both teams did very well, both the attorneys and the witnesses, was mastery of the exhibits. These are very difficult exhibits this year, and especially with the expert testimony, being able to use multiple exhibits at the same time and show how they interrelated, but then also using that on cross-examination against her. I thought that that was extremely effective by both teams, and that's not something that we always see in this type of competition. So I really wanted to commend both teams on that. Something to keep in mind, how many of you are seniors? Okay, so most of you, but so maybe for your underclass, maybe team members who are sitting in the gallery. The cross-examinations were very, very good, and I think that the witnesses, for the most part, had a good handle on sometimes it's just better to give a yes or no answer and not fight on every single question. I would say maybe there were times where some of the witnesses fought when they maybe didn't need to. Sometimes just saying a yes or no and letting the attorney move on to the next point and then fighting when it matters is a little bit more effective. But attorneys, be careful sometimes about using characterizations that a witness is going to want to fight you on, like saying that things are important or things are critical or someone is good at what they do. Those are going to be the questions that the witnesses are more likely to fight on versus keeping them very fact specific and building up to maybe why something is important without using that word. That can be very, very effective. I mean, there was definitely some of that, but that's something that takes a long time to master. And then I also wanted to commend both teams on your use of theme. You both had very strong themes up front that I heard in the closings, and then you I heard in the openings, and then you reiterated in the closings. And I also wanted to commend both of the closing attorneys on citing to your opponent's theme in your closing and pointing out how it wasn't quite on point. So I thought that that was very well done by both teams and wanted to commend you on those. But overall, great job. This was a great trial.
And you put a bunch of lawyers on a platform like this, and we're all going to have something to say. You know that. But I have to say first, wow, this was a wonderful experience. I did this a half a dozen years ago, and it was a wonderful experience then. But boy, you really knocked our socks off. I was very, very impressed with all of you. Both the witnesses and the counsel, in terms of your demeanor, your courtroom demeanor, your ability to keep the entirety of the courtroom in your mind as you were talking and as you were testifying. You continually kept track of your colleagues, you continually kept track of us, and that is sometimes a very hard skill to learn, and that was very, very impressive. I think also, all of your ability to think on your feet was wonderful. And that is, again, a very good skill to take with you wherever you go, whether you become a lawyer or not. So I was very impressed. We were all very impressed. I'm also wanted to acknowledge the good work as well that OCLRE does in this area and has done for years. The Ohio State Bar Foundation and the Ohio State Bar Association both are proud supporters of this organization and this program, and it has done wonderful things for many young people over the years, and it's one of the programs that really makes us proud to be lawyers. And we thank you for putting your all into this.
My comments are going to be somewhat general, but I got involved in this program back in the mid-90s, and an attorney in Bryan County who coached a small team, and they actually won the state championship a couple times. But he told me one time, you ought to start coming to the state competition. It's really a good thing. It's a good program. You'd really enjoy it. And I said, well, Mike, I think maybe I'll do that. So I saw him a number of years later. He's retired now, but I asked him, your team, at that time he was still coaching, I said, I know how you've had success, and I know how I can see how good the teams are that compete. But tell me, how many hours do you put into this? And his answer was, and your answer would probably be a little bit different, but he said, if I recall correctly, he said, we put in 20 hours a week, and that's 10 hours with me, and that's another 10 hours without me. And I thought, wow, that's a lot of hours. And he was talking, I said, when are you starting that? In October through the time that you compete. And so my daughter is a senior, and she's not participating in mock trial. Unfortunately, her high school doesn't have mock trial, which is something after she moves on to college I'm going to try to get corrected. But I know there's such a thing as involvement in a lot of activities, and I'm sure that you are, but this is something that you have gotten involved in depth, and I think you're to be commended for that. And as I looked at both teams, I mean, the attorneys are all very strong, the witnesses were all very strong, and you just did a tremendous job. The legal advisors, I mentioned how much time Mike, from the person who got me involved, I don't know if he wants to take credit for that or not, but he got me involved. I don't know how many hours you put in, but I know the legal advisors and teachers do a tremendous job, and I know they put in more hours than most people do at any of their volunteer activities, and so they are to be commended. Parents and friends who are here, you should certainly feel very proud of your students, your daughters, your sons, your friends, because just reaching the final is something that, you know, most everybody that participates in mock trial never does. And you reached the final, and you deserve to be in the final. I mean, both teams were just excellent. So wish you, for those that are seniors, certainly wish you the best in your future endeavors, because I'm sure you have bright futures. And for those of you who aren't seniors, I look forward to seeing you back here again next year. So with that having been said, Ryan and OCLRE, I agree, does a tremendous job. So.
All right, well, thank you so much. If I could ask the judging panel to please come down and join us on the floor. We're going to go through some of the awards. So on behalf of the Ohio Center for Law-Related Education, our sponsors, the countless volunteers who participate in this program, the countless hours put in by your teachers, we thank all of you for the support that you give to this program. We began writing the case file in early May, and to finally see the students performing the case that has been written, it really is a real pleasure. And there's no greater example of that than the trial we saw today with our two teams. To give you a sense of how this is going to go, we are going to first award the best attorney, then we'll do the best witness award. We will announce the winning team. We will then ask the runner-up to come to the front and introduce each of their students to receive a trophy gavel to recognize their role. And then we'll have the first place team come up and also introduce their students to receive a gavel. So without further ado, we are going to announce the James E. Phillips Outstanding Attorney Award, which this year goes to Miss Lark Yan. And our 2018 Outstanding Witness Award goes to Emily Haseki. And our 2018, the 35th Annual Ohio Mock Trial State Champion is Sylvania Southview High School Team Jasper. If your attorneys could come to the front to grab the trophy, we'll have you all introduced afterward. Yes, we'll have it. Nicely done, congratulations. We'd also like to recognize the 2018 35th Annual Runner-Up, Springfield High School Team Platinum. Please come to the front. If your attorneys could come up. As soon as she's done taking pictures, that's when I'd like to introduce your coach, Katie Osborne, to hand out the gavels for this year. And I just introduce each of your students, and we have gavels for them.
First, our wonderful witnesses, starting with Jake Kearns. Emily Haseke. Our senior, who is on the other side of the case and had to watch this round, Riley Moody. Amin Dingra. I can't forget our bailiff, Austin Tyree. Come on over. And last but certainly not least, my daughter, Caroline Osborne.
We'd also like to recognize the Springfield High School teacher coach, Mr. Scott Hambrick. Scott. And at this time, I'd like to invite up Mr. Denny Lyle to introduce the students from Sylvania Southview High School, Team Jasper.
Thank you. I think on behalf of Springfield and Southview, we'd like to thank the judges too before I announce the individuals. We appreciate your time, the dedication you've shown, particularly Judge McBride, who's been here around so long. The members of the team competing this year happened to sit on the bench this round, but it was Ananya Holdenkar. Our bailiff, Felix Griffin. Our witnesses, Shruti Dixit. Our second witness, Kaylin Lee. And our attorneys, Elizabeth Roca. And certainly not last but least, Larkian. And I'm sorry, if I could say one more thing, I'd like to introduce my wife, Vicki Donovan Lyle, who's actually been the assistant coach throughout this whole year. Congratulations.
Absolutely. And actually, Kate, would you mind grabbing the trophy as well so they can? And we're going to ask Springfield to come up at the end as well with photos for the judges. Yes, thank you. Alrighty. Let's go put this in the middle here. Gets taller every year. Congratulations, Sylvania. And we will post all pictures on our website as well, so don't worry. You'll get a good photo, we promise. And at this time, I'd like to invite up the Springfield High School Team Platinum to please come to the front for photographs with the judges. Nicely done.
Thank you. Thank you. I'm so proud.
Congratulations. Scott, I think you should hand. You know. All right. And with that said, congratulations to all of our teams. On behalf of the Ohio Center for Law-Related Education, our sponsors and our volunteers, we thank you for your time, and thank you all for joining us today. Take care.
You've been watching the 2018 Ohio Center for Law-Related Education High School Mock Trial State Championship. Congratulations to both teams, runner-up Springfield and the winning team, Jasper from Sylvania Southview High School. They will now head to the National Championship in Reno, Nevada. To purchase copies of this program or to view it for free online, visit ohiochannel.org, where you can also view live and past video coverage of your Ohio government, including the Supreme Court of Ohio. Thank you for watching, and we'll see you next year.